I do. Let's just copy it real quick.
Counsel, could you and your client please come up to the podium? Thank you. This is docket 24706 FH, People of the State of Michigan versus Colby Mann. Counsel, your appearance for the record.
Good afternoon, Your Honor. EPA Bart Buxton on behalf of the people of the state of Michigan.
Tyler A. Smith from the Office of the Public Defender here in Ingham County. I do appear on behalf of Mr. Mann, who's standing to my right.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. We also have Agent Kakowski here on Zoom. And sir, you pled guilty to count 1, embezzlement. Agent trustee, $1,000 or more, but less than $20,000, punishable by 5 years. You recall that?
Yes, ma'am.
Have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
Have you had enough time to speak with your attorney?
Yes, ma'am.
I have allegations by way of probation violation that reads as follows. Count 1, on or about January 8th, 26th, defendant failed to enter the TRICAP methamphetamine program. Count 2, on or about January 9th, 2026, defendant failed to report to probation within 24 hours of leaving TRICAP and any time thereafter. Counsel, are those the allegations that you have discussed with your client?
They are. I've discussed them in detail and given appropriate advice. He has reviewed the charging document.
Thank you. Mr. Kakowski, are there any amendments?
There's not, Your Honor.
Thank you. Counsel, will this be a plea or a hearing?
It's a plea, Your Honor.
Are you waiving further arraignment?
Yes.
Sir, you'll be pleading to both counts, is that correct?
Yes, ma'am.
As to count 1, failure to enter the TRICAP methamphetamine program on or about January 8th, 2026, how do you plead?
Guilty.
As to count 2, failure to report to probation within 24 hours of leaving the TRICAP program on or about January 9th, 2026, and any time thereafter, failure to report, how do you plead?
Guilty.
Did anyone force, threaten, or coerce you to plead?
No, ma'am.
Did anyone promise you anything that caused you to plead?
No, ma'am.
You pled of your own free will?
Yes.
You did that after consulting with your attorney?
Yes, ma'am.
And you've been satisfied with the representation of your attorney?
Yes, ma'am.
And you understood as part of the rehabilitation and probation, you were to follow all recommendations of probation, orders of this court, all recommendations of probation would be orders, would become an order of this court, and you were supposed to complete TRICAP, and you failed to do that, correct?
Correct.
And you also understood that you were to regularly report to probation, and you also failed to do that since January.
Yes.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made. I also find by preponderance of the evidence that he is guilty of violating probation. Counts 1 and 2 will enter. Counsel, may we go into sentencing?
Absolutely.
And what is the recommendation of probation? And could you also tell me, has he completed anything?
Yes, thank you, Your Honor. A little oversight of Mr. Mann's probation term has been very limited, as he did abscond. Basically, the week after he was sentenced to the probation term, we spoke on the phone briefly at that time. He failed to report a warrant issued from your office. We were back in front of you in December of 2025. Your Honor, the court gave him another chance to go to TRICAP. Him and I spoke on the 23rd of December about the expectations of probation and the expectation of reporting to probation regardless of completing that program. And then I was notified in the first week of January that he had walked away from the facility upon arrival. So in terms of probation, he has completed nothing at all, Your Honor.
Thank you. And your recommendation is?
Yes, Your Honor. We're asking for revocation, 365 days credit for 36 days served. Thanks.
And those 36 include prior plus now?
Correct, Your Honor.
Thank you. On behalf of the people?
Your Honor, that's what my notes indicate as well, so I would follow that recommendation. Thank you.
Counsel?
Yes, Your Honor. I think there are some mitigating factors here. Certainly the account of the timeline that Mr. Kakowski gave, I have no reason to dispute that. I will differ with him on one matter. That is, he referred to absconding. The violations before the court are 2 technical violations. There is no violation listed for absconding. That was not added.
Well, let me be clear. It says defendant failed to report to probation. Failure to report absconding, it really is tantamount to the same thing, isn't it? Or do you have a different interpretation? He didn't report and it's now May, so we lost track of him for what, 5 months?
That is accurate. What I mean to say, I guess more precisely, is that the document we've all been presented with lists 2 technical violations, no non-technical violations. So I'm not trying to make a mountain out of a molehill here. I'm just getting this on record.
Your Honor, if I may.
You may.
That the count 2, I believe we're speaking on the failing to report to probation, was a technical at the time, but statute states after 60 days of non-reporting to probation, that technical then turns into a non-technical. So that would be a non-technical after the 60 days of failing to report to probation.
Okay, appreciate that clarification.
Thank you.
And so this is not the first violation he has. He had a technical violation by not reporting to probation on or about November 4th, 2025, correct? So we've had 3 violations at least. Anything else, counsel?
Oh, yes. I just wanted to get the procedural out of the way. I spoke with Mr. Mann earlier today at some length about why he would do such a thing. This is not compliance with probation. This is not, just to put it in a straightforward way, this is not a good decision not to engage in probation, not to engage in treatment. However, it's important to consider the context when these things come up. Mr. Mann is not the sort of person who often comes before this court, that is, who does not take things seriously, who perhaps has spite in their heart with regard to the court, with regard to probation and everything else. I don't think that's Mr. Mann. He indicates that at the time he failed to engage meaningfully in probation at all. He had a reason to believe that his children in Battle Creek were being investigated by CPS. That matter was later closed without any further relationship with CPS. Sounds like there are behavioral troubles, other matters there that needed attending to. And Mr. Mann's priorities, as I think it ought to be with any person with children, his priorities, his heart is with them. The court will be in receipt of communication, perhaps earlier this week, from the mother of those children, who, in short, was exhorting court staff, myself as Mr. Mann's attorney, anyone who received it, to please allow Mr. Mann to be available to them, and to, if he is remain on probation, have that transferred to Battle Creek. In short, there are people who need him, and Mr. Mann made the admittedly pretty serious error of putting aside his responsibilities to this court, excluding them entirely, and working to be with his family. That's not the way this is meant to work. That's why he's in custody now, and that's why he's experiencing the specter of possibly staying in custody for a significant period of time. I would respectfully request the court take these factors into account in fashioning an appropriate sentence. I think it is also important for the court to be aware that while Mr. Mann does have a significant substance history, he does not appear to me today to be in use. He does not appear to be shifting blame. Does not appear to be shifty, so to speak. I've worked with quite a few people with substance issues, and I see in Mr. Mann the early signs of someone who can get away from those things. I don't think this is the individual to essentially warehouse, to put on 365 and just let it be at that. I'm not asking for, I suppose, any additional consideration over and above other individuals in a similar position, just for the court to consider The context as I've laid it out. We've got the mother of the children, Mr. Mann here, currently ready to change. And there are many signs, positive signs here that it's going to happen. So I would ask that the court maintain Mr. Mann on probation with the understanding that if he does anything even broadly similar to what he's done before today, that would be the end of it. There's no question.
Sir, what would you like me to know?
First of all, I do take responsibility completely, obviously, for leaving TriCap. It's probably one of the dumbest things that I have done. I should have took advantage of the program rather than letting it intimidate me, I guess, for lack of better words. I did go through a separation with my ex-wife, and there was, as my attorney said, things going on in Battle Creek, which clouded my judgment. I was wanting to get back to my kids. And I did it in the wrong way. I should obviously. They just been going through a lot with schooling and stuff, and I really want to get back to them, and I'm hoping that the court can help me do that, to get back to them. And I've rekindled the relationship with my children's mother, and it's not just my kids there, it's her kids too, who I've formed a bond with. There's 7 kids in that house who depend on me, count on me, and I've already let them down, and I don't want to continue to keep doing that.
Let me get this straight. You value your relationship with your children, you've gotten a better relationship with your ex, and you want me to send you not recovered when you've chosen your drugs and this lifestyle over them, right back to them.
I wouldn't put it like that, Your
You
Honor.
wouldn't, I would. You didn't avail yourself of treatment. You used them as an excuse to defy the orders of the court, not go into treatment. You think you can help them by going back to them. CPS will terminate your rights faster than you can blink if you show up there high and with your criminal history. We have an adult history of 18 times you've been in front of a court. So how are you going to help your family, especially children, impressionable children who need to be protected, when you are high on meth and causing decay in your brain? Explain that one to me. I'm a bit confused.
No, you're right. I don't feel that it's possible to do unrecovered. I haven't used in over a year, and not that it's any different, probably worse in my opinion. My drug choice was heroin. I don't know why the record has methamphetamines down there, but nonetheless, just as bad.
Heroin is just as bad. I don't know. It has meth. It probably was, let me see what you plead to. You should plead to,
These embezzlement charges, Your Honor.
yeah, but was there prior meth?
Unfortunately, I don't have access to the internet, so I cannot look that up on our.
Okay, so heroin's your drug of choice. Makes little difference. You are teenagers. I'm teenagers. Teenagers look to you and everything you did wrong, they amplify it and say, well, I don't have to listen to you. I can do what I want because you did it. You want your teenagers, your impressionable children, to use illegal drugs, to have larceny, to have retail fraud, all the things that you've done, drive without a license, etc. I could go on. Those are minor. You have some major things. You want them to do all that?
Absolutely not.
Well, you have to be the example, sir. You're a crappy example. What you need to do is say, yes, I did all those things. Be accountable. Go to treatment and say, but when I make a mistake, I am accountable for it. I get rehabilitation. I ask for help. I go to treatment because I want to have a safe home for you and for me and for our community. But you haven't done that, sir. You have not shown me that you've been clean and sober and that you can provide a safe home. So tell me what's going to change.
Well, I do think I would benefit from some type of treatment. I was actually attending AA meetings when I was out there, which did help. But I really can't tell you nothing more than besides after rekindling that relationship and being around my children, for the time that I was, I realized that there's more to life than drugs and running the streets. Like, there's so much more. And I just want that back.
So why were you using drugs?
I don't have a good excuse. I don't think there's ever a good excuse for using drugs, but it started when I lost my first brother to a suicide. And then within less than a year, I lost my other one to a murder. So I made some dumb decisions.
So you decided to put down the grief and pain with illegal drugs. I see you have a history with cocaine. Is that right or wrong?
That's correct, Your Honor.
Okay, so we got cocaine, we got heroin. Did you ever use meth?
I have used it before, yes.
Okay, so now we get at more of the truth. It's not just meth, it's basically whatever you can get your hands on to shut down the pain. Do I have that right?
You do, Your Honor.
Great. Okay, Mr. Kukowski. Is TRICAP the best place for him? Can he go back there? Or is another program better?
Yes, Your Honor.
Or-
TRICAP, yes, TRICAP believes in many chances of coming back to them. They basically expectation is that people are not going to make it the first time and to continue to bring them back if that is an option.
So here's how it's gonna go. I'm gonna give you a chance for treatment. And I'm gonna make a note, and your record clearly speaks to it, that if you don't do well, not only will I consider a year in jail, but I will consider prison. Have you ever gone to prison?
Yes, Your Honor.
Did you like it?
Not really.
Do you like wearing those jumpsuits?
No,
You like being away from your family?
definitely
You
not.
like coming in front of judges?
No,
I got a lot of no's, so what do you like?
my family, my freedom.
Then choose it. It's all your choice, sir. We didn't choose you to be here. You got a criminal history that's horrible. You didn't choose to lose both of your brothers, but they're with you. And if they're standing there with you, what do you have to say to them? Because I believe they're standing there with you. And they're telling you to live a life for them and not behind bars. Isn't that what they're telling you?
Yes, Your Honor.
So what do you have to say to them back?
I'm sorry, but I'm gonna do it. Show and tell, I guess, Your Honor.
You know, they're just in another form. You're here with a purpose. And that purpose is to do good in the world, not coming before judges. And part of the good that you'll do was to be accountable for those children that you chose to have. You didn't wear a condom, you didn't abstain from sex, you apparently wanted children, but you're an absent father. And your brothers didn't have a choice, they're with God now. You have a choice to be with your children, and you have chosen your drugs and criminality. So you need to have different choices and not be an absent father. You continue to use drugs, have this criminal behavior. Michigan is a state that is unforgiving, and at some point, there'll be a petition to terminate your parental rights. How do you feel about that?
I definitely do not want that. Breaks my heart to even think about it.
Well, think about it. Carry your children's pictures, and when you decide to drink, drug, commit crimes, you look at those faces who don't deserve that. And you get on a higher ground and you ask for help. So you said you're going to AA. What step are you on?
Honestly, I feel like I've just had to restart and really just take a step back and look at things from the beginning, because
What's step one?
admitting we're powerless over our addiction. Their lives become a minute.
Well, at least you got step one right. Okay. How long does it take to get into TRICAP?
Your Honor, as soon as I can send the referral today, hopefully beginning in the middle of next week, they can have a transport van, take them up from the Ingham County Jail.
Okay. He's getting 365 days jail. We're continuing probation, adding back any time. And if I given him 18 months, now he's got 24 months. If he continues to fail, you don't even need to bring him in front of me if it's something minor, just increase it to the 36 months. And we can increase it to the 5 years. If it's something major, he doesn't show up, he's positive, there's things are not going well, please immediately bring this in front of me. And we'll look at where he goes next, because I don't know what else to do. If he's not going to avail himself of your help and the resources that we have, then he'll be in somebody else's hands, under somebody else's watch. So then I would, the next report, I don't just want the report once I sign the bench warrant. When we are at hearing, I want an updated pre-sentence investigation report. Have I been clear, Mr. Kukowski?
Yes, Your Honor.
Do you understand what I mean, sir? Have I been clear,
Yes, Your Honor.
counsel?
I think so, Your Honor.
Great. Very, very short leash. Make it good to the community, yourself, and most of all, your children. Because I'm not believing what you say. I deal in evidence. I want to see the evidence. Prove it to me.
Yes, Your Honor. Thank you.
And Mr. Kukowski is on top of things. He can call me at midnight and I'm gonna respond and I'm gonna sign a bench warrant. So you work it out with him and prove to all of us that you're clean and sober. Now, when was the last time you held a job?
About a year ago. year and a half.
What did you do?
Speedway.
Okay, can you get another job there, or is there some other place you wanna work?
I don't have a preference, as long as I can maintain employment, I'd be satisfied.
Why can't you maintain employment?
I feel like I can.
What's the longest time you've worked at one job?
2 years.
Okay, well, let's try to break that record.
Yes, Your Honor.
So he has credit for, what did you say, 36 days?
Correct.
All right, well, he will only get a PR bond when he is transported and actually sets foot at TRICAP.
Understood.
Then he'll get credit for those days that he served, the balance will be held, and we'll see how we use them or don't use them, it's all up to him. He will sign all necessary releases so we can verify that he is doing what we need him to do, what they've asked him to do, and he will complete all aftercare. He will attend AA, NA, or CA 3 times per week, and he will have a sponsor within 120 days of his release from TRICAP. The sponsor must have worked the program to get clean and sober and been clean and sober for 5 years. He will be part of a work seek program and any trade school program if he desires that. If he is in school as a full-time student, he only needs to work 20 hours per week. If he is not a full-time student, he must work a minimum of 30 hours per week and not give his employer any cause to terminate him. I do not know if he's supposed to be paying child support or not, but if he is, there will be a wage assignment as required by the friend of the court. If that's going on, I simply don't know. I don't have that paperwork, but he will pay his child support on time and keep the friend of the court and family court judge apprised of all employment. He will be regularly tested, and if any test is positive, there will be a secondary test to make sure that it's a positive and not a false positive. And if it is a positive, he'll be brought before this court immediately. When he is employed, the testing will be Monday, Wednesday, Friday, random on the weekends. That way he can work out his work schedule. And then you can reduce the testing once we are satisfied he's on the right path to sobriety. Do you have a place to live, sir?
In Battle Creek, I do.
Okay. And this can be transferred to Battle Creek upon verification that they accept him and that he has an actual residence that is suitable in Battle Creek. Is there anything else I need to order on behalf of probation
I think you have it covered, Your Honor.
On behalf of the people,
I would agree, Your Honor.
counsel,
It's quite comprehensive, Your Honor.
you understand, sir?
Yes, I do, Your Honor.
Sure, please honor those children. If they mean to you as much as you say, we will not have account 19. We will not have crime. We will not have alcohol, illegal substances. We will have a fit parent. You are not a fit parent to go home to them now. You understand?
I do, Your Honor.
You have 42 days to appeal to request appellate counsel. Since I've given them jail time, please hand them his appellate rights. If you're unhappy with this, feel free to appeal. Do you acknowledge your appellate rights, sir?
Yes, ma'am.
Thank you, Your Honor.
Maybe Christopher Johnson next.
How many months did he extend? So he was on 18.
Yeah. Johnson first. Waiting for Wanji. So when Wanji comes up, we can bring him up and do it.
Johnson first.
Yeah, I'll just do Johnson first.
This is docket 256761FH, People of the State of Michigan versus Christopher Johnson II. This is a sentencing. Counsel, your appearances for the record.
Good afternoon, Your Honor. AP Bart Buxton on behalf of the people of the state of Michigan.
Good afternoon, Your Honor. Jacob Sarts, the fourth Assistant Public Defender here on behalf of Mr. Johnson II. He's present at the podium. He's standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. I like your sweatshirt.
I
Cool
appreciate it.
design. All right. Have you taken any medication yesterday or today?
No,
Are
ma'am.
you supposed to have medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
Have you had enough time to speak with your attorney?
Yes, ma'am.
And have you reviewed the pre-sentence investigation report?
Yes, ma'am.
And you pled guilty to count 1, uttering and publishing punishable by 14 years. You recall that?
Yes, ma'am.
All right. And on behalf of the people, are there any corrections, additions, deletions?
No changes in the body, Your Honor.
Council, any corrections? The date would be changed to
Oh,
May
that's
1st, so we'll do that. I'll do that as we go along. Are there any others besides the date on behalf of defendant?
No, Your Honor. Thank you.
All right, so I'm changing that in the basic information sheet. I've changed it on the cover page. And I don't know if it's in the information.
It is, Your Honor, at the bottom of the first paragraph.
Yeah, changing it there and then on page. On instant offense, I'm also changing it, that's 11 of 11. All right. Any other corrections?
I believe the prosecutor had one correction to the guideline scores. I don't believe we have a basis to object to it, Your Honor, so I'll defer to
What is
Mr.
that?
Buxton.
I would agree, Your Honor. OV12 is currently scored at 0. OV12 is in regards to contemporaneous felonious criminal acts. It is scored at 5 points if 2 contemporaneous felony criminal acts involving other crimes were committed. And Your Honor, there were 2 uttering publishings that were dismissed as a result of this plea, so I believe that OV 12 should be scored at 5.
And I hear there's no objection.
No objection. Thank you.
OV 12 is 5, unless there's something else, it would be a total OV of 20. Is that still level 2?
It is, Your Honor.
Let me change that on the basic information sheet. I changed that so everything is consistent, but let me just look at what probation has to say, see if they mentioned that on the narrative. No, everything looks consistent to me. Is there a victim here?
No, Your Honor.
On behalf of the people?
Yes, Your Honor, I would just ask that you follow the recommendation in this case. And I know that we had agreed on the restitution, but I just want to make it clear that the restitution is to LAFCU in the amount of $1,700.
And that includes the dismissed counts. It was.
Correct, Your Honor, that's in regards to all 3 counts.
I just wanted to make that clear. Counsel, anything further?
I just ask that you follow the recommendation. Thank you.
Thank you. Counsel, on behalf of your client.
Thank you, Your Honor. Mr. Johnson, very sorry for his poor decision-making. He understands that money doesn't pop up for free. He just was desperate. He made a very bad choice. And he has learned a very important lesson here, that you got to work hard to get your money. That you got to be very careful of these check scams. And this has been a scam that people have been running for, decades, Your Honor. I mean, in my experience as a defense attorney, so 19 years, I've been seeing cases like this. And, Mr. Johnson just made a very poor decision. And it appears that the bank was the victim here. They lost the money. The account holder apparently had her funds refunded. And Mr. Johnson has learned a lot from going through this experience. He served a extended jail term on a probation violation. So he served quite a bit of time, and that gave him an ample opportunity to reflect on things, to work on improving himself. And to his credit, Your Honor, since he's been released, and while he's in jail too, I mean, he had a very complicated and very difficult situation with his family as well. And he learned some very valuable lessons there too about the need for him to be out and to stay out and be there for his family as well while he was going through this process. And at 26, Your Honor, we have every reason to be optimistic about Mr. Johnson. He can turn his life around. In my interactions with him, he appears to be a mature young man with a good head on his shoulders. He just struggles with impulse control. But at 26, he's really starting to figure out his life, Your Honor. So respectfully, I request that Your Honor go with the recommendation of the 2 years probation here. Since he's been out in early March, to the best of my knowledge, Your Honor, there's been no new charges, no problems with him out on bond. He's been working hard to try to get his life back on track, and he will continue to do so if Your Honor grants him that opportunity. And he wants to prove it to you, Your Honor. He wants to earn it. He can successfully complete that probation, and at 26, that he's really turned his life around. Thank you.
Sir, what would you like me to know?
I just want to apologize, Your Honor, for being in front of you again. It won't happen again. Right now, I'm in the middle of getting my CDL. I'm working to get my CDL right now. I'm working hard to take care of my 2 kids right now.
Well, you got 4 kids. What about the other 2?
Well, I'm with them. I'm with their mom. So I'm more full-time than my other 2 kids. I get them on the weekends, but full-time, I take care of my 2 kids.
What about getting your CDLs great? How about your GED or high school diploma? What happened?
I haven't started it, but I already knew I was gonna have to end up getting that with this
I'm
probation.
assuming you want your 4 kids to graduate.
Yes, ma'am.
Well, it starts with you, sir. They're gonna look at you and say, I get to drop out, you did. How does that make you feel? That's exactly what they're gonna do. So what's interesting to me is it looks like from this report, you grew up with a single mom, not uncommon. You've got a couple single mom, 3 single moms. You've made 3 women single moms. And then you turn 20 and the crime spree starts. What happened at 20 that caused you to be in front of judges 11 times?
bad mistakes, just making bad mistakes, growing up and learning from. Yeah, I making horrible mistakes. That I do regret, I do very regret. Because I started getting in trouble at an older age. I wasn't even just making dumb mistakes.
So why did you drop out at 10th grade? Are you a learning disability, or you didn't care, or what? Couldn't get a ride?
See, back then, I used to think like, all the stuff that I'm using in school, I'm not gonna use it in the real world. So what's the point of me going think like that? But then as I got older, it's like, I'm gonna need this if I want a job, if I wanna get a good job, if I wanna be successful in the real world, I'm gonna need my GED. So I do regret not getting my GED too.
So there's a program at LCC called Reconnect. You can go there for free. You can get your college education and your high school, okay? You're the perfect candidate for it. What you said is interesting to me because I have this constant conversation. I have twins who are in high school. And my son often says, why do I have to take this class? I don't like it. I'm gonna say the same thing to you that I say to him, and you're older, so hopefully it'll sink in with you. He still fights me on it. There is not one job, including mine, that doesn't have parts of it that we want to not do. But we have to do it to maintain the job, to maintain our integrity, to follow through, okay? I didn't like math and science. I'm not good at them, I don't like them, I went through it. Because I wanted to graduate, because I wanted to go to college, because I wanted to go to law school. I didn't like all my classes in law school. I thought I'd be a corporate attorney. I had about 3 days of corporations and thought, oh, no, never. But I finished the class because I had to. And I strove for excellence. I didn't always get the grade I wanted, but I did everything I could to achieve it. Life is full of starts and stops and starting again, but you don't get anywhere unless you complete all the dots. And if you want your CDL, and then you get some work doing that, and you don't complete the job, you don't get paid, you lose your license, you get lawsuits, you don't get a good reputation. You're not gonna like everything you do. But part of it is to develop that armor to say, I can do it, throw it at me. I don't like doing this, but I'm gonna do it because I wanna get to the next stage that I do like. And you have got to have that mindset for success. You have to teach that to your children. Counsel, you like everything you have to do as a lawyer?
I'll invoke my right to remain silent, Your Honor.
That says it all, see?
Good one.
Prosecutor, you like everything you gotta do as a prosecutor?
I'm your brother counsel statements.
Okay, see? Deputy, you like everything you do?
Same as I have stated, Your Honor. Silent.
Unanimous, okay, I can go around the whole courtroom and ask everybody. Y'all gotta do things that we don't wanna do, but that's how you climb the ladder of success. Challenge yourself, climb the ladder. Pay attention to those things you don't like, because you know what, you might like them in the end, but regardless of how you feel about them, it gets you to the next step and the next one and the next one. And when you are successful, your children will also strive to take those steps and be a success, and maybe challenge themselves to be more of a success than you, because that's what our kids do. I hope that's what you want for yourself and your kids. Because this record that you have amassed is pretty horrible. Now tell me about the 3 mothers of your children. Are you paying child support?
For one,
Why not for all 4? You live with 2 of them.
because I take care of my kids, so how we, like, the government doesn't need to be in our business if we have a good co-parenting relationship.
Okay. So is your name on all 4 birth certificates?
Yes.
Well, that's something. Sir, this is your fourth felony conviction. Do you know what happens next if you commit another felony?
Yes,
What?
I won't be here for a long time.
That's possible, but understand that it all increases. And once you have charge where the people decide to put a habitual fourth on it, it's a 5-year felony, it goes up to 15 years. If it's, if it's under 5 years, I think it goes to 15 years. If it's 5 years or more, it goes up to life. You wanna wear a jumpsuit in prison for life?
No, ma'am.
Think about that, sir. Because your record is not looking good. Let's clean it up now. You're young enough, you've gone through, you're 26, your brain's fully developed, let's make better choices. You will be on probation for 24 months. If you do really well, you can do half of that and get off probation. Otherwise, I'll extend it to 36 months or possibly 5 years. It's up to you. I can also send you to jail or prison. So let's not make any more mistakes, sir. You shall not use, possess, consume, purchase, or be in the presence of alcohol, illegal drugs, or drug paraphernalia. You will complete an adult education or GED program. I would urge you to check in that Connect program at LCC. It's a fabulous program. And you will complete cognitive behavioral, so you learn to make better choices, and whatever additional treatment there is, whether it's individual, group, I'm not sure. They have a lot of new treatments that deal with impulse control. I don't know if you need to see a psychiatrist to get on some meds. I don't know exactly what the impulse control piece of that is. I'm not a therapist. But sir, if you have these sort of urges that you can't control, there is medication, there is counseling, there's lots of things that can help you, so ask for help. Because otherwise, whether it's me or some other judge, we're just gonna toss you in the jail or the prison. Don't be a number to your children, don't be a picture on a worn out photograph for your children. Be present. Be responsible. You'll sign all necessary releases so we can verify that you're doing what you need to do in treatment. You'll obey all court orders and all recommendations from probation and all treatment providers. Recommendations become orders of this court. You will not engage in any assaultive, abusive, threatening, or intimidating behavior. You will not have any contact with any known gang members or any gang colors, insignia, or tattoos. You will not have any contact with anyone on probation or in the Department of Corrections or who's on parole. If you end up having contact, just let probation know. As long as you're all in good standing, then I'll allow the contact. You'll contact probation today, go downstairs, make and keep your first appointment, keep all subsequent appointments, and if you need to reschedule, that's on you. You chase probation, they don't chase you.
That's not.
You'll allow probation into your residence at any time for probation supervision without a warrant and submit to a search of your vehicle, cell phone, residence, and computer if there's reasonable cause to believe you have items that might violate the conditions of your probation. You must report any arrest or police contact, personal protection order placed on you, loss of employment or change of residence to probation within 24 hours. Weekends and holidays are accepted. So if something happens on a Friday, tell us on Monday, Monday's a holiday, you tell us on Tuesday. You will be part of a work seek program and not give any employer any cause to terminate you. If you want to change employment, you will first seek permission of probation. You will serve 365 days jail with credit for 241 days. The balance of the jail is held. You may serve more time. I can also send you to prison. Let's not have that happen. You will pay restitution in the amount of $1,700 to LAFCU, and once you're employed, you will execute a wage assignment and figure out what comes out of your check so that by the end of probation, it's all paid. If you don't have enough money to live on and pay your support and do all the things you're supposed to do, get a second job. I'm not gonna listen to any excuses. You owe this money and you got 4 children to support. You will pay crime victims assessment in the amount of $130, estate costs in the amount of $68. It's a total of $198. I'm waiving probation oversight. I am waiving all fines, costs, attorney fees, finding that you're indigent for all of that. You will not recreationally use alcohol or marijuana. If you need anything with those contents, you'll provide a prescription and follow all recommendations of the doctor and whatever the prescription says. You'll not use any object as a weapon. You'll not own, use, possess, or have any guns, ammunition, or any weapons of any kind. You'll not use any object as a weapon. You'll not be in the presence of anyone who has those items or any other contraband. Is there anything else that I need to order on behalf of the people?
Not from the people, Your Honor.
No, Your Honor, thank you.
Anything you're confused about, sir?
No, ma'am.
All right, you have 42 days to appeal and to request appellate counsel. Please hand Ms. appellate rights.
That's that form right there, sir. Do you acknowledge receipt?
Yes, sir.
Thank you.
Good luck to you, sir, and I still have your correct address on Turner Street.
Yes, ma'am.
All right, please go down to probation and follow through. I look forward to releasing you successfully from probation. Got a lot of hard work to do. Don't have to do it all at once, but you do have to do it, all right?
Yes, ma'am.
Thank you, that's all for the record.
Thank you, Your Honor.
Thank you.
Henry next.
You Cameron Anderson next.
Brian,
Yeah, Judge.
will you send an email to Agent Kukowski and ask him to add a that one and then grief counseling?
Okay.
I forgot to order. This is docket 25-6595 FH, people of the state of Michigan versus Cameron Avery Anderson. Counsel, your appearances for the record.
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people, state of Michigan.
Good afternoon, Your Honor. Jacob Starks, the fourth assistant public defender here on behalf of Mr. Anderson. He's present at the podium. He's standing to my right.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Sir, have you taken any medication yesterday or today?
No,
Are
ma'am.
you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
Have you had enough time to speak with your attorney?
Yes, ma'am.
This is a final pretrial conference, so this is where we decide how this case is going to go, whether it's going to be in a plea or a jury trial makes no difference to me, but we have to have a cutoff because I don't allow people to plead on the day of trial because that would deprive somebody else who could have had a trial. All right. On behalf of the people, was there an offer?
Yes, Your Honor, there was an offer given. That offer would have been to an added count 2, attempted carrying concealed weapon. There would also be an agreement to no upfront jail. However, the defendant would have to not seek HYTA status for that plea.
How old is it?
He's 20, Your Honor.
Was he? Well, if he doesn't seek it and I grant it, does that violate your agreement?
It would, Your Honor, based on the reading of the agreement, if Mr. Anderson was inclined to accept that offer.
It would, and Your Honor, that offer is given based off of Mr. Anderson's history. I don't want to go into any further details.
All right, thank you. Is it both very accurate and complete?
That's as the plea offer has been explained to me. Yes, Your Honor, and I had an opportunity to explain that to Mr. Anderson. Mr. Anderson is not interested in accepting that offer at this time. He requests to proceed on to his scheduled jury trial. Your Honor, I would note that Mr. Anderson is set for jury trial on May 22nd, 2026. Unfortunately, I would potentially have a scheduling issue. I'm on the docket in front of Judge Cole for a CSC first trial. It's People v. Isolela. That's case 25-006900FC. Granted, there's a possibility that case could plead out, Your Honor, but that case is set for the 26th, and that's a capital trial, Your Honor. So respectfully, I would request at this time that Your Honor consider moving Mr. Anderson's trial date. My apologies, it's just one of these scheduling issues, and that case 25-0069-6900 is a capital trial, Your Honor.
Is that in custody?
No, fortunately, Mr. Isolela is out of custody. And I'm not 100% certain how the priority would work here, but I would presume, because that's a 25 file, and so is Mr. Anderson's, that it would be a pretty tough and close call And because that's a capital trial, Your Honor, I would be potentially stuck if that one had to go. It's not the type of case we could just get coverage for very quickly either, given the severity of the charges there.
Well, what about this case? I mean, a seasoned attorney can prep this pretty quickly. Can someone else in your office do this?
Well, Your Honor, at this point, I've had a very long relationship with Mr. Anderson. I've been representing him now for an extended period of time. We'd only be talking about 3 weeks. Our office is incredibly busy right now. It would be a hardship, Your Honor, to ask one of my colleagues to take on a trial like this with only basically 3 weeks' notice. Mr. Anderson, to his credit, since he's been out, has been staying out of trouble to the best of my knowledge. We don't have any speedy trial concerns at this point because of he's out of custody. I don't think there'd be any prejudice if Your Honor did request, if Your Honor did grant my request for adjournment here. Obviously, this is being made by me, so the timeline is attributable to the defense here. So he's been doing a good job since he's been out, to the best of my knowledge. And respectfully, and unless people have some grounds to disagree, I don't think it'd be prejudicial to the prosecutor at this point if we had to adjourn this trial date out.
Sir, are you not accepting the plea offer?
Yes, ma'am.
And what's the potential success rate on behalf of the people?
Your Honor, this is a carrying concealed weapon case. This is pretty open shut.
Okay, and so hearing that, sir, and having discussed all of this with your attorney, you don't want the plea, because this is the last day that you can accept the plea. We just go on to trial. You go on to trial, if you are found guilty, it will be a 5-year felony. You understand that?
Yes, ma'am.
And you still want to avail yourself of your right to trial? Do you want to talk with your attorney for a minute? I mean, here's the thing, sir, it's 5 years versus 2.5 years with an agreement for no upfront jail. You go to a jury, I don't know what I'm gonna hear, but I'm gonna hear a lot more detail than I'm gonna hear at a plea. And I don't know whether I'm gonna give you upfront jail or not. I don't make any predetermination, and maybe you've got a really good defense. I don't know anything about your case, so I cannot advise you, nor am I in that position. I'm a judge, not a lawyer representing you. But I want you to understand that to keep cases moving and to make sure everybody has time on my docket, I have to have cutoffs. So this is your cutoff. You can't change your mind later. So counsel, talk to him for a few more minutes. I'm gonna take another case and then see if he still wants to go to trial.
Well, I would note, just on behalf of Mr. Anderson, in terms of plea negotiations on our end, Your Honor, we have just been simply requesting that Mr. Anderson be given the opportunity to ask for HIDA. And certainly, as a fallback option, Mr. Anderson could plead as charged, which would be a 5-year. And to the best of and he was granted HIDA successfully on another case, which I'm not going to get into here. So there's no issues in terms of the timing of things. He, unless I'm completely mistaken on this, but he could get HIDA again, and he would at least have that opportunity, Your Honor, if he played straight up to the 5-year. So I'm certainly happy to follow up with negotiations with Mr. Buxton, but kind of a sticking point that we're at right now is if Mr. Anderson takes this deal, he has no chance of getting HIDA unless, and if he accepted that offer, that type of opportunity would be completely cut off from.
So are you telling me that what he wants to do is plead to the 5-year with HIDA?
Your Honor, I made that as a counteroffer to Mr. Buxton, but Mr. Buxton, from what I understand, has very strict marching orders on what he can offer Mr. Anderson.
Well, that's what he can offer, but when somebody pleads, and correct me if I'm wrong, I am always happy to learn, but when someone pleads straight up, it's not the people's choice, it's my choice as to HIDA, not the people's.
You are correct, Your Honor. Because he's 20, so you could grant it to him even over the prosecutor's objection. What the prosecutor was proposing doing, though, was tying it into his plea offer, which that would have complicated things on Mr. Anderson's end.
May I for the people, what's your position on him pleading straight up and the court giving him HIDA? That's something that's always on the table, isn't it?
That is, To my understanding, that is what's on the table, Your Honor. There would not be any additional offers from the people because he'd be pleading straight up. If that's what you wish to do, Your Honor, that's out of our hands.
I'm just looking at options, so he's fully informed and can have it, because he's looking at me like, I don't want to do this, I don't know what to do, I'm confused. I know he has a very good attorney who fully explains everything very, very clearly. Probably more clearly than most lawyers. So sir, I'm gonna have you go talk to your attorney, and just so you're clear, because today's the cutoff, so you have three options. One is a jury trial. If you go to a jury trial, I absolutely cannot give you HIDA, because that is not allowed, because the legislature says it's not allowed. Okay, it's not part of our laws. If you plead straight up, I can give you HIDA. It's something I like to do. I always do it unless my hands are tied somehow. If you want to get the 2.5 year, the people are opposed to it. They've made it part of the deal, so I can't give you HIDA. So you got three choices. Go spend another couple minutes with your attorney, and then counsel, let me know. Thank you.
Thank you, Your Honor.
Yeah, bring up all. We're gonna do Joshua Oliver next.
So, counsel, in the event he decides to plead, we have another HIDA. We'll do the HIDAs at the same time. If he doesn't, we'll just get on with it.
Understood.
And I'm sorry, are they getting Mr. Oliver?
You're getting Mr. Oliver right now.
Thank you.
Great Oliver, yeah. He needs to go. You heard from him, Mr. Brown?
Have not,
Okay.
but I heard from Mr. Jackson on this case.
Did you have an opportunity to speak with Mr. Oliver? Okay, so we're just waiting for him. Mr. Steve. You already have information?
Yes, ma'am.
Is there a, oh, I see, so I think we have two that were put together, right?
Yes, Your Honor.
Oh, okay, so there's a count one on one sheet and then 2 and 3 on the other, is that right?
That's correct.
All right, counsel, you've gone through both of them or all three of them? When they're done on separate sheets, I don't always know that you get them. Do you have both?
I don't have, I do have an extra copy. I'm not sure how.
Do you need a moment with them? Do you need a moment with them to go over those?
Yes. Just.
Sure, on the other side.
Sorry.
Thank you.
Sorry.
Well, Ross, good
Oh,
afternoon
afternoon.
now, yeah, I know, day goes by quick.
Yeah.
You know when you're ready, Ms. Weinstein?
I am.
Oh, you are? All right, sorry, I must have missed you saying that. All right. This is docket 21728 FH, people of the state of Michigan versus Joshua Oliver. Counsel, your appearance for the record.
Good morning, or good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan, your probation officer.
Alex Meisling, Your Honor.
Thank you.
Good afternoon, Your Honor. Magandang everyone. She for Mr. Oliver who's at the table by my side.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. Sir, have you taken any medication yesterday or today?
Yes.
Is it anything that would interfere in your ability to understand the court or your attorney?
No, ma'am.
Is there medication you're supposed to be on that you're not on?
No.
Any sign of fever, COVID, or other illness?
No, ma'am.
And there are 3 allegations against you. Have you had an opportunity to speak with Ms. Wanji about all 3?
Yes.
Okay, did you need more time with her or are you good?
No, I was confused for a minute when you said 3 allegations, but you talked about the prior thing.
Yeah, okay, so you pled guilty to controlled substance possession of a controlled substance known as methamphetamine, punishable by 10 years, recall that?
Yes,
And
ma'am.
you were placed on probation.
Yes, ma'am.
I now have 3 allegations against you for violating probation. It includes as follows. Count 1. Defendant violated and then he failed to report to Ingham County Probation on or about November 16, 2023. Is that the one?
That's correct, Your
Has he
Honor.
been abstaining since then?
24 months, Your Honor, yes.
And so it would be at any time thereafter?
Yes, Your Honor.
So I'm going to add that as an amendment. Any objection, Ms. Wanji?
No, Your Honor.
Thank you. And then count 2. On or about September 24th, 2025, defendant assaulted, resisted, or obstructed a police officer who was making a lawful arrest. Count 3. On or about December 23rd, 2025, defendant possessed methamphetamine. Is that the extent of the violations or are there others?
That is it, Your Honor.
All right, as to count 2 and 3, I take it there are new charges, there's a new file, is that correct on behalf of the people?
Yes, Your Honor, there are new charges. Our office has gotten in contact with 54A District Court, and he should be getting arraigned on those shortly.
All right, so I leave it up to you, Ms. Wanji. We can hold everything in abeyance, or you can plead or ask for a hearing on this failure to.
But I will say, I apologize, Your Honor. I will say that there are new charges. However, the additional counts are in regards to a case in Clinton County that he has already pled and been sentenced on.
Oh, so why are these new, so the new charges are not?
The new charges are unrelated and they have not been issued as a count yet against him.
And are they drug related?
They are, Your Honor. They're delivery and manufacturing of methamphetamine.
Okay,
What is that? I'm sorry, Your Honor.
well, you know what delivery and manufacturing.
No, I do, but I don't know what
Apparently,
charges.
well, I don't either. Apparently, they're getting their act together, putting them in writing, and they're going to advise you of that, and then you'll be arraigned and you'll be brought before me on yet another file.
Oh, okay.
Sir, you need to not say anything because your rights remain intact. I'm sure that Ms. Wanji will talk about that with you further. I don't know what you know or don't know, but let's keep your rights intact, okay?
Yes, ma'am.
Okay, so Ms. Wanji, would you agree that these counts 2 and 3 have been dealt with, and so this would not incur any other violations?
Yes, Your Honor.
All right, so is his intention to plead to these 3 counts or not?
Yes, it is his intention.
And are you waiving further arraignment?
Yes, Your Honor.
Is that correct, sir?
Yes, Your Honor.
And you chose to plead after you discussed these issues with your attorney?
Yes,
And you've been satisfied with her representation?
yes, ma'am.
Are you pleading of your own free will? No one's promised you anything?
Yes, ma'am.
All right. Sir, as to count 1, violating in that you failed to report to Ingham County probation on or about November 16th, 2023, and any time thereafter, how do you plead?
Guilty, ma'am.
And sir, as to count 2, on or about September 24th, 2025, assaulting, resisting, or obstructing a police officer who was making a lawful arrest, and this would have been in Clinton County, is that correct, counsel?
Yes, Your Honor.
In Clinton County, how do you plead?
You're guilty, Your Honor.
And sir, as to count 3, possessing the controlled substance known as methamphetamine on or about December 23rd, 2025, how do you plead?
Guilty.
And was that also Clinton County? And those charges have been dealt with, is that correct? Ms. Wanji, or sir?
Yes,
Clinton
ma'am.
County, okay. Sir, you understood that you were supposed to report to probation each and every time.
Yeah, no, I knew I was supposed to report, but I didn't. I didn't know I was supposed to report. I never got that far with probation.
But you got that far with me. I read you these requirements, and it was that you would be on probation for a term of 2 years or 24 months. How did you think that was going to occur if not to report?
No, I knew I was supposed to report to probation, ma'am. I'm saying I didn't know I was supposed to call every time there was a incident or whatever, but.
Well, that's not the violation, isn't that you didn't report the
Yes,
incidents, but you're
yes,
supposed to report, and we haven't seen you since 2023, except by law enforcement in other counties.
Yes, ma'am. I don't know if you want to hear what I have to say about it or not, but
I'll ask you that
Yes,
in
ma'am.
minutes, but you understood that you needed to
Yes,
report
ma'am.
each and every time. You also needed to stay crime-free.
yes,
And
ma'am.
in fact, evidenced by your convictions in Clinton County on a couple of different counts, you have not stayed crime-free, correct?
Correct, ma'am.
And you didn't engage in probation the way you should have.
That's correct.
So you've accomplished nothing since I saw you in 2023, except for criminality.
Well, yes, ma'am.
All right. I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made. He counts 1, 2, and 3. He's admitted to, and the evidence is very clear on it. So by preponderance of the evidence, they shall enter. And he's now guilty of violating probation and contempt of court, counts 1, 2, and 3. Maybe go into sentencing, Ms. Wanji.
Yes, Your Honor.
What's the recommendation of probation?
Yes, thank you, Your Honor. Given that he absconded immediately following his sentencing for a period of 24 months and then was subsequently convicted and sentenced in Clinton County on new felony charges, we would be asking for revocation of probation. He is entitled to 210 days credit. We would ask that you sentence him to 210 days with credit for time served, so he may be transferred back to Clinton County Jail to complete his sentence there. He has approximately 250 days left on that. Thank you.
Counsel?
Your Honor, we would ask the court to follow the recommendation.
Sir, you're too old for this.
I know, ma'am. When I got out of Ingham County, I ended up getting out of the hospital like with congestive heart failure, and it was very bad. I let everything spiral out. I tried to go into treatment and was told that, and I would stop using meth. But when I went to go to Bear River, they told me that because I wasn't actively using, my insurance would not cover it. And, you know, I have no excuse other than, you know, I gave up and I spiraled down, you know, it's costing me everything. Since I've been in Clinton County, I haven't been sitting on my butt. I've gone through treatment. I've completed the Clean Slate MDOC treatment program. I've been active with church and Bible studies. I've also taken financial freedom seminars and foundations for better living. And I'm trying to start to repair my relationship with my family. I mean, I can't, I have no excuse for my behavior, but that's what was going on. And, you know, I apologize.
Why didn't you repair your relationship with God and your family before you found all of that in jail?
Because I allowed drugs in my life, and that, you know, clouds everything. And it's a way of not having to live, you know. Well,
You have been using drugs since what, the last, 24 years?
on and off for the last 30-something years, but, you know,
So you got
last 10
caught.
years.
Yeah, you got caught in the last 24 years. I mean, I have 4 counts that say 24 years. It could be 30, it could be longer. What happened to you?
A lot. I mean, it's I happened to myself. That's all I can say. You know, I myself.
Sir, people are not born to wake up one day and say, I'm gonna go use meth. And meth kills your brain, kills your body, unless you want to be in a body bag, which sounds like that's your next step. You got a bad heart, you're using meth, it just screams up, I want to die. So what happened so horrible? Do you know? You said a lot of things, but there's a turning point where you just gave up 20 years ago.
Yeah,
Did you ever address those issues?
I'm starting to, but not fully. You know, so it's a lot of history to go through and a lot of things that need to be repaired. I mean, I don't have anybody to blame but myself.
So tell me about your stay in Clinton County. Have they ordered you to go through any kind of mental health treatment?
No, ma'am.
Do they have any in the jail?
I don't know. I know that CMH comes there for some people, but they don't.
All right, so counsel, if I order him for 365 days with the credit, but have it served concurrent, can he be sent over to Clinton County and served there? So what I'd like to do is order that he have some mental health treatment. If they didn't order it, they should have. And so I want to make sure he gets some mental health treatment. Can we send him over there, or does he have to serve our jail and then go over to Clinton?
I'm actually not quite sure, Your Honor.
Deputy, do you know? No?
Give me one moment, Your Honor.
Okay. But sir, that's a huge misstep. You really need some treatment so you don't fall back into this pattern. I'm not convinced you'll seek it on your own. Or you might not have the opportunity to.
We're not quite sure, Your Honor, so ultimately leaving the court discretion, I apologize, I don't.
All right, so here's what I'm gonna do, and
You're gonna make me a coach,
yes,
please.
All right, sir. Sir, I am unhappy with your trauma not being addressed. So here's what I'm going to do. I'm gonna kind of give you an alternate sentence, and somebody will probably come yell at me, but in this way, I can keep jurisdiction of your new cases that apparently are coming up, and then I can get you treated under that file. If I close this file, what happens, sir, is that I lose jurisdiction, and you may get me, you may get one of the other judges, and having the background here, I think is important, so I want to hopefully keep you under my watch and get you some mental health treatment one way or the other. This crime speaks to it. You only have a history from whenever you suffered the trauma that you admittedly know and just haven't sought help except to shove it down with meth. And unless you have a death wish, I'd like to see you in some treatment. So I'd like to maintain a little bit of control if I can. If I can't, so be it. Maybe you can ask the next judge for trauma treatment. So I'm gonna sentence you to 365 days with credit for 210 days. Those can be served concurrent with Clinton County and in Clinton County Jail. You will abide by Clinton County's sentence and whatever treatment they've given you there, including the substance abuse treatment, but I also want mental health treatment. I don't know what they have available there, but mental health treatment programs you should avail yourself of if they have it, but certainly community mental health is in every community, and community mental health should come and see you and work with you to address those trauma issues that you're having that you want to shove down. Let's vomit them out, deal with them, and live the rest of your life safe and happy and healthy and crime free. We all benefit from that.
Yes,
Now, if
ma'am.
you want to go see God early and explain all this to him, you just keep on this path. I'd like to use this as an opportunity for a teachable moment for you about how to deal with your trauma and make it a life experience, because whatever trauma you've been dealing with is not getting better. It's only going to get worse.
Yes,
And
ma'am.
you gotta deal with it, or you're gonna keep shoving it down and be in that body bag.
Yeah, I came to that realization and, yeah, I understand what you're saying.
It is a tough pill to swallow, but sir, you gotta ask for help. And then you have to seek it, you gotta make the right choices. And I understand there's going to be some new allegations against you in this county. And we'll talk about those if and when they come and what we do. But I think revoking this probation and handling it this way is the start of what I hope will be a plan to get you totally healed. If not, prison or a body bag or both wait for you. Make the right choices, sir. Do the hard work.
Thank you, ma'am.
You have 42 days to appeal and to request appellate counsel. You, I don't know if there's any monies that ever accrued, but all waivable fines and costs, probation oversight, whatever are waived. You just have the mandatory monies to pay, and I don't care when those get paid.
Yes, ma'am. Thank you.
Do you acknowledge your appellate rights, 42 days to appeal and to request appellate counsel?
Yes, ma'am.
Good luck to you, sir. Thank you.
Thank you.
Things to do, Steve, next. Okay. Never mind, do we want to go back on record on?
Is this going to be Hyden?
Yes, please,
Do
Your
we
Honor.
need to go into the courtroom and Zoom room?
Yes, please, Your Honor. Thank you. Somebody let the mouse up here.
You know, you still have to, you still have to buy out.
I do right here. This one.
I'm trying to get us into the break over.
Do I have that?
You don't have the police sheet yet.
No, I don't.
Tell Be back. This is docket 25-2982 FH, people of the state of Michigan versus Clifford James Sleeper. Counsel, your appearances for the record.
Good afternoon, Your Honor. EPA Bart Buxton on behalf of the people of the state of Michigan.
Good afternoon, Your Honor. When I get to one, you for Mr. Sleeper. Please. Come aside.
Counsel, would you approach? I'm sure.
We've had a chance to talk.
Okay, well, as soon as things are due, it's very short. That's your- We are going to see what officers do. make sure you. All right, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth and the defense of perjury?
I do.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
Yes,
Is it anything that would interfere in your ability to understand the court or your attorney?
no,
Any sign of fever, COVID, or other illness?
No.
And you've had enough time to talk with your attorney about this matter?
other than the new information that you just enlightened them with. I don't
Okay.
know.
Well, the new information you can certainly talk with your attorney about is I have a letter that I rarely ever see from Lansing Police Department, who the officer talks about the victim being terrified, learning that you were no longer on tether, and your behavior and not changing, and you can read it for yourself. So what I told your attorney when we just handed everybody this letter, is that you'll be on a very short leash if I accept this plea agreement. So if you decide to violate, that would be strong evidence that you ought to be in prison. So if you want to proceed, that's fine, but I want you to know what I'm thinking based on this letter, and what will happen is you can refute it by having good behavior. If you have bad behavior, that will underscore it, highlight it, and probably send yourself to prison. Do you understand?
Yes, I
Do you
understand.
wish to proceed with the plea?
Yes,
Okay,
I don't have no intentions of making any contact with her. I'm gonna try to avoid any place in Lansing that she's at, or,
oh, you don't try, you will.
yeah, I will, that's right. And reason I say is, the only time I'm gonna be, I live in Saginaw, I plan to go back to Saginaw, Brant, Michigan. And the only time I'm in Lansing is to see an uncle or my daughter and grandchildren.
Okay,
That's it. I have no other business in Lansing.
okay, well,
I mean, it was in the past gonna be a place that I wanted to move back to, because I grew up here. But I'm not gonna create this friction between me and that family.
okay. But don't find a family in Saginaw that you want to have friction with either. Stalking behavior. Sometimes what I see is it's an uncontrollable urge where you need to have control over someone. I don't care where they live, in Saginaw, Flint, Bay City, Lansing, Chicago, it doesn't matter where. So if you have that kind of personality, get some help, because otherwise you're walking right into prison.
Right. Yeah.
Everybody makes me promises at that podium, but is very
Yeah.
swift to forget them. I will be swift to remind you. Are we clear?
Yep, you're clear.
Great.
Can I ask one thing, that somehow in the record of this plea, it shows that the charge was related to text messaging, not in person?
I don't care. Contact is
Yeah, I
contact.
just,
You just made that record, okay, sir, but let me
Okay.
understand.
Yep.
Let me help you understand what
Mhm.
contact means. Appears you don't have an understanding. Contact means any contact. Text, flowers, Hallmark cards, smoke signal, carrier pigeon, phone call through third parties, any kind of contact. You get creative, I'm not creative.
Right.
My creativity lands you in jail or prison. Got it?
Understood.
Great.
Thank
Do you understand what contact means?
Yep.
And so if this person appears naked at your door, what do?
I'm not answering the door.
And what do
And I'm
you
gonna
do?
call my agent or,
Call 911.
right.
Okay,
Mhm.
we're clear about that too.
Yes, we are.
Because I don't want to hear anything about, well, she did this or that, because
Yeah.
you have choices to make. Your choice is not open the door, call 911 and go the other direction.
Yes, that is right.
Because I don't have jurisdiction over her, but I have jurisdiction over you.
Right.
Okay. That being said, do people wish to proceed with this plea agreement?
Yes, Your Honor.
All right, sir, are you a US citizen?
Yes,
And did what you're pleading to occur while you were on bond conditions, parole, or probation on another file?
parole.
And will this be a violation now of parole?
I'm already serving that time.
You're serving
Yeah,
them, so
yeah,
there'll be no
correct.
other repercussions and we can proceed. Ms. Wanji, is that correct?
Yes, Your Honor.
All right, thank you. And did I ask you if you took any medication?
Yes, you did,
All
ma'am.
right, very good. Let's move on then. On behalf of the people, what is the plea agreement for the record?
Yes, Your Honor, the defendant be pleading to an added count 2 of stalking. That is a misdemeanor punishment up to 1 year and or $1,000 with up to 5 years of probation. Upon successful plea and sentencing, count 1 in the habitual offender status will be dismissed. There is also an agreement for the defendant to serve the full 5 years of probation with no early release for said probation.
It's 1 year and or what?
1 year and or $1,000 and up to 5 years of probation.
Yes, I got that part. And is there any restitution that's owed?
Your Honor, I don't believe that there is, based
Okay,
off of the
is-
previous pre-sentence investigation report.
Is the victim going to be here? Can we move into sentencing or not?
Your Honor, I would request that this set be for sentencing at another time.
All
The victim
right,
is not present here currently.
thank you. Is that full, fair, accurate, and complete?
Yes, Your Honor.
Sir, is that full, fair, accurate, and complete?
Yes.
And counsel, you're waiving reading count 1
Yes, Your Honor.
as to the added count 2.
Yes, Your Honor. People of the state of Michigan versus Clifford James Sleeper. State of Michigan, County of Hingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in added count 2, stalking, did engage on or about March 13th, 2025, at 120 West Michigan Avenue, Lansing, Michigan, 48933, Hingham County, State of Michigan. The defendant did engage in willful course of conduct involving repeated continuing harassment of Taylor Marie Caswell. The conduct being such that would cause a reasonable person to feel frightened, harassed, intimidated, and terrorized, and said conduct actually causing Taylor Marie Caswell to feel frightened, harassed, intimidated, and terrorized. Contrary to statute. This is a misdemeanor that is punishable up to a maximum of 1 year and or $1,000 and up to 5 years of probation. And it gives a piece of dignity of the state of Michigan.
Sir, did you understand what was just read?
Yes, I do.
So you understand stalking is a 1 year misdemeanor and or $1,000. It'll be mandatory 5 years of probation, and you will also be placed on a GPS tether. Do you understand that?
I wasn't informed about the GPS tether. I was told there wouldn't be.
Well, I'm going to put you on a
Okay.
GPS tether. I want you to know that up front, because I was just looking at the history. We've been here before, and this is a horrible history. And I don't know, I'm going to watch you under GPS tether at least for a while, and we'll see what happens. But I want you to be very clear that I will be putting you on a GPS tether, statute or not. I can do it and I will. You understand?
Yeah.
Thank you. All right, and it looks like you signed the advice of rights form.
Yes, ma'am.
Did you read it before you signed it?
Yes,
Did you understand what you read?
yes.
And
Oh, and apologies, Your Honor, I don't think I mentioned it, but it is on the plea agreement. This will be a no contest.
that's based on civil liability?
Correct, Your Honor.
Counsel, you agree with that?
Yes, Your Honor.
And sir, you agree with that?
Yes,
All right. And you had the opportunity to ask your attorney any questions you had before you signed the advice of rights?
yes.
Do you have any questions of this court in regard to your rights?
No, ma'am.
And you understand that by pleading, you're giving up your right to a bench trial or jury trial, the presumption of innocence, the ability to cross-examine witnesses and evidence, the ability to choose to provide a defense, to remain silent, or choose to testify. You're giving up all of that,
Yes, ma'am.
including the right of an automatic appeal, which you would have had you gone to trial. Now you'd have to ask permission from the Court of Appeals to appeal, and they only will grant that if they agree with the importance of your issues. You understand all that?
Yes, ma'am.
As to count 2, stalking, the 1 year misdemeanor, how do you plead?
No contest.
And that's based on civil liability,
Yes,
sir? All
yes.
right. And you chose to plead after talking with your attorney?
Yes,
And you've been satisfied with the representation of your attorney?
yes,
And your plea has been freely given, no one forced, threatened, or coerced you or promised you anything we haven't made a record of, is that correct?
Yes, that's correct.
All right. And sir, do you understand that this plea agreement would be off the table if you violate the law between now and sentencing?
Yes.
Has anyone told you what else that will do at sentencing?
No.
Because I don't know, I will wait to hear from the victim and you and your attorney and prosecutor, and then I'll make up my mind. Do you understand?
Yes.
All right. And do I have a police report?
Your Honor, I was actually going to approach with the description of the offense narrative in the previous PSI, if I may approach.
You may. I've been presented with the description of narrative from the previous pre-sentence investigation report that was on July 8th, 2025, and I've been provided page 3 and page 4 and page 5. And of relevant part, it reads that on or about March 13th, 2025, the victim, Taylor Caswell, contacted Detective Thalen with the Lansing Police Department regarding defendant Clifford Sleeper, who had been found guilty previously by a jury of 6 counts of CSC 3rd degree in Ingham County. And the victim in that case was this same victim. And she stated that she received several text messages from a phone number that she believed was defendant, although she was not familiar with the actual phone number. And Detective Thalen, Thielen, asked LPD analyst Hall to complete a workup. And it noted that the phone number was registered for defendant. And the sex offender registry was checked and he was an active compliant registrant. Detective followed up with Saginaw, Michigan Department of Corrections parole. Spoke with the Agent Spalding, who is the defendant's assigned agent, and confirmed that he was on parole and not on tether. And that parole required that defendant not have verbal, written, electronic, or physical contact with the victim, either directly or through another person, and he was not to be within 500 feet of her residence, school, or place of employment. And the agent was able to confirm the phone number was in fact defendant's. There were numerous texts that also mentioned the victim actually was in reference to possibly her daughter. And there were a number of texts, it looks like, and they included that he would be off parole in a couple of months and that they would be looking for apartments, and there were multiple unknown callers. And he noted that her voice still sounds the same. March 17th, 2025. The victim reached out to Detective Thalen again due to additional messages being sent to her from yet another phone number. And what was said to her was specific things that defendant would say. And there were several references to the CSC case from 2013. To include statements like, "My love for you is and always will be true to you." there was certain extractions done, and all 3 phone numbers, apparently there was a line of dates and phones used, and all 3 phone numbers were used by defendant to contact the victim. I think that would cause a reasonable person to be in fear, and the requirements have been met. But counsel, would you like me to read anything else specifically? It's a rather long report, but I think I've summarized it. Is there anything else you want me to note?
I think you have, Your Honor. I will state that it also states that such conduct actually caused the victim to feel that, and there is a victim statement on the
Oh, yes.
last page.
See that on page 5. And she says, my name is Taylor Castle. I have not went to counseling. I've been having some sleepless nights where I stay up all night thinking, and it's been rough. It's just kind of rough to really talk about it. Well, I did get cameras because I was scared of not only my life, but my daughter's life. I didn't like how somehow he got my phone number out of the blue and started texting me, asking to hang out. It freaked me out. So I said I would prefer, I'd feel more safer if he wasn't here out in public. Because when he was in prison, I was safer and I was able to do more things with my family than when he's out. I was afraid he would find me somewhere or have somebody sneak up to me. This put me in shaking fear, and it's rough trying to talk to friends and stuff, and they've been trying to help me through it. Pretty much, I'm just scared for my life. I think that summarizes everything very well.
I think so as well, Your Honor. The people are satisfied.
The defense is satisfied.
Thank you. Our counsel where promises, threats, or inducements other than those already placed on the record.
No, Your Honor.
Thank you, Your Honor.
Has court complied with the court rule?
You have, Your Honor.
You have, Your Honor.
Thank you. I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count 2 will enter. Count 1 is hereby dismissed. Any outstanding warrants relating to this file are hereby recalled and dismissed. As to a sentencing date, we don't need a PSIR. We can just go to sentencing in the next couple of weeks.
Yes, Your Honor.
I don't know if we have a date or time that's available. I can call.
I would just need enough time to writ the defendant out from MDOC.
Can we fit sleeper in for a misdemeanor plea and a plea, I'm sorry, sentencing? He just pled in a couple of weeks, so we don't have to wait 6. Does May 12th at 3 work?
That's fine.
That,
I should be able to get a writ by then.
okay, if not, then let us know, we'll move it.
Will do, Your
All
Honor.
right, thank you, thank you. May 12th at 3, sir, you'll be written out, and we'll talk then. No contact, no contact, no contact.
I hear you clearly.
If I hear that there's contact, I will personally call the warden. Got it?
Yes, ma'am.
All for the record.
Thank you, Your Honor.
Last case is Dougherty, Your Honor.
What I'm saying. This is docket 24489 FH, People of the State of Michigan versus Michael Shannon Doherty. This is an evidentiary hearing. Counsel, your appearance for the record.
Thank you, Your Honor. Randall Berman on behalf of the people. I'm seated at the council table with Michigan Department of Corrections Probation Agent Gale.
Good afternoon, Your Honor. Toby White. I'm here on half a voice on behalf of Mr. Doherty. He's with me at the council table.
Thank you. Sir, please raise your right hand. You swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do, Your Honor.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
Yes, ma'am.
Does that medication help you think more clearly?
Yes, it
And
does.
you've been on it for quite a while now?
Yes, ma'am.
Is there medication you're supposed to be on that you're not on?
No,
Any sign of fever, COVID, or other illness?
no.
And have you had an opportunity to speak with your attorney?
Yes, I have.
And Mr. White,
Yes, ma'am.
do you believe your client is oriented to date, time, and place and does understand what's occurring?
I do, Your Honor. I've had conversations with him recently and today. I do.
Thank you. And this is an evidentiary hearing on behalf of the people. Are you ready to proceed?
Your Honor, yeah, it's on the docket as an evidentiary hearing. It's my motion, it's the people's motion. I call it to accelerate delay of sentence and enter the felony convictions and set matter for sentencing. And if I can explain a little bit by way of history.
Okay.
Might benefit everyone involved. So in August of 2024, we entered into a delayed sentence plea agreement where the defendant pled guilty to 2 of the felony aggravated stalking charges. And if he was successful on his 1 year of delay, they would enter as 2 misdemeanor stalking charges and he'd ultimately be sentenced on those. In March of 2025, it became apparent that the defendant had, I believe that the defendant had gone off his medication. He had filed a almost 400-page federal complaint suing a litany of federal, state, and local authorities, people involved with the case. And in that filing were harassing exhibits. And so on April 1st of 2025, I did an emergency motion to revoke the defendant's bond. That was set for hearing on April 2nd. Soon after that, on April 1st, the defendant appeared in this building in the probation department purportedly to serve a subpoena for his federal lawsuit. He then was up in my office, at which point in time, the deputies, Ingham County Sheriff's deputies, came up and took him into custody and brought him before Your Honor. One of the conditions of the delayed release was no contact with Ingham County unless it was court. And I further explain why I believe that's a violation, but nonetheless, the court, in front of the court, without the court's own eye, revoked bond because he was here, and then ultimately was jailed. And we did a referral for competency, and it wasn't until a few weeks ago that he was restored to competency. So now we're here, and instead of having a show cause for a bond violation or a pretrial service form sent up for Your Honor, because it would take me longer to explain to everyone everything that's gone on it was easier for me just to do it, so I just did it as a motion to accelerate the 1-year delay. And I'm just asking the court after the hearing today to enter the 2 felony convictions. I have a total of 6, maybe 7 witnesses. 5 of them are the victims involved in the case who will testify to the harassing nature of the filing that was done. And so I'm gonna go a little bit out of order because of the time of the day. Not all of them are in the area, and I'd like to get them in and out of here if I could. So that's how I plan to proceed. It's not really an opening statement, but I felt it best that everyone understand where we are. That it's my motion to accelerate the delay of sentence. And ultimately, I'm just asking the court to enter the 2 felony convictions. The court has already set a sentencing date in June. And at that point, probation can once again try to do the PSIR, and we can come back for the sentencing.
Mr. White, are you in agreement with proceeding like this, or are you and your client in agreement with just simply entering the 2 felony convictions, or what is your position on all of this?
Thank you, Your Honor. No, we're not in agreement with entering those as 2 felonies. I think that what is indisputable is we know that Mr. Doherty had a cognitive breakdown. That is why he was in the forensic center to begin with. We know that after several months, he was able to be restored to competency. And at that point in time, he was released to go to Charlevoix, where his parents lived. He went to Charlevoix. When he was in Charlevoix, he worked with a doctor, the family doctor. That might not have been the best choice, but he went to the family doctor. And he also was involved in counseling. Now, during that period of time, prior to April 1st and March 28th, the late spring dates that were referred to by Mr. Berman, he did go off his medication. However, he did it in consultation with his doctor. So that was a mistake. The medication he was put on was a mistake too. It's taken quite a while for them to stabilize and realize that he needed different medication. But due to the fact of his incompetence, I think it is harsh and inappropriate for this court to find that he violated his probation terms because he didn't. And at the appropriate time, I can go through these. And if you look at the actual order itself, and if you look at the allegations for this motion, they don't hold up. He was incompetent, and thus being incompetent, he's not making these arguments about, well, I had a legal lawsuit, I have a right to be in the building. All right, that was all done when he was on a psychotic break. He's making the argument that he's been stabilized, and if we get to it at some point, the people at the forensic center believe that he's completely different from what he was the first time around. And on a side note, they want the bed because they think he should be released up to Charlevoix under appropriate psychiatric care and medical care. And when you put all that together, this should be in probate court. This is a mental issue that he's having. And so I know we're here and I know you can deal with it and I know you've dealt with it in the past. But what I'm saying is what we're trying to do is rehabilitate him. And it looks like the rehabilitation process is working. And the last thing I'll say before I sit down is that I've been before you how many times, and people have, this is kind of the inverse. It's usually people that, like the previous gentleman, that can't get off of drugs. And he is the inverse. He wasn't happy with his medications. He consulted with his doctor. The doctor, supported him in getting off his medications. And then the federal lawsuit drops on everybody, making it a mess. So that's my position, is that we should proceed to the misdemeanors.
Understanding all of this, has anybody petitioned the probate court to assist him when he has these bouts?
No, should have been done. As you know, I was off the case during the bulk of this period of time.
Yes, but I also know this has been going on a long time, so let's proceed, see where we're at. It is concerning that no one's taken that next step to probate court, because that's where we're headed, unless at some point he goes off his medicine again and he ends up in prison. I mean, it becomes limited and limited. I have a box of papers that were filed, a box of pleadings. clearly this case cries for help, but now we have to figure out where we are with this, but somebody needs to petition probate court.
Yeah.
All right, thank you.
I agree, thank you.
Counsel, you may proceed.
Thank you. I dispute some of the things that Mr. White said. It might be easier if we could turn the Elmo on.
All right,
And
do you need help doing that or? We're good, okay.
so, Your Honor, just for everyone involved, the first set of testimony I wish to take is going to refer to the Exhibit 5 attached to my motion, which is exhibits that I pulled from the federal filing that pertain to the victims who were protected parties under this court's order. I'm not alleging that the defendant had contact with them. They never got served with the lawsuit. They did find out about it, and as we're about to learn, the court may or may not determine that what was filed and alleged against them was harassing, which is a violation of this court's order, one of my other exhibits. So it's Exhibit 5, Your Honor. It's attached to my motion. If you can look at the top of it, you'll see that it has all the federal court stamping, verifying that it is what it is. And for everyone following, the page numbers I'm referring the witnesses to will be at the bottom right corner of the document. And with that, the people's first witness would be John Polderman.
Thank you. Please raise your right hand. Do you swear or affirm the testimony you're about to provide be the truth, whole truth, and nothing but the truth and the penalty of perjury?
I do.
Thank you. Put your hand down. When you are comfortable, pull the chair right up to the microphone. When you're comfortable, please state and spell your name for the record. Put up a little bit farther, and then you can bend that if you need to.
For the record, Your Honor, I just spoke to Mr. White and voluntarily sequestered my lay witnesses. Obviously, Ms. Gale from probation is assisting me. There's another probation officer from up north who's supervising the defendant that is on Zoom.
Okay.
I'm not sure I need to call him, but we'll get to that. Sir, state your name and spell it for the record, please.
John Polderman, John Polderman.
And where were you employed in March of 2025?
I was at Stevenson and Bullock, or am at Stevenson and Bullock.
Is that your current employer?
It is.
Prior to that, where were you employed?
Simon PLC.
And what is Simon PLC?
A law firm.
And are you in fact a lawyer?
I am.
Did you have occasion to be involved with Michael Doherty and or his business?
It did.
And in what capacity?
Court appointed receiver.
And what judge appointed you to be a receiver?
Judge Dragonchuck.
Based upon your receivership duties, did you oversee a business related to Mr. Doherty?
Yes.
What business was that?
Rebel Industries.
And without going into the specifics of the receivership or that lawsuit, at some point in time, you became, I guess we could say the victim now because he's been convicted of something, of a bunch of texts and harassing emails, so to speak?
Yes.
Okay. And then in March of 2025, were you aware of a federal lawsuit that was filed by Mr. Doherty?
I was.
And how were you made aware of that?
Several people contacted me, letting me know that there was a federal filing.
And As an attorney, do you have access to what's called the PACER system?
I do.
What is the PACER system?
It's the federal court filing system that allows you to access documents that have been filed.
If you're aware, do you have to be an attorney to have a PACER account?
I don't believe so. But you do need a password and a login.
But if anyone were to search your name in PACER, it would come up as a defendant in this case, would it not?
It would,
And they would see the allegations that were made against you by Mr. Doherty?
yes.
Your Honor, if I may approach the witness with a copy of Exhibit 5 so we can go through that.
You may.
I did show that to Mr. White. Mr. Polderman, I'm going to ask to direct your attention. You have a copy, Your Honor? Well, I'll put it on the Elmo, that's fine.
Thank you. Yeah, the Elmo would be helpful. Thank you.
Showing you page 4. And I believe, yep, you can see that right on the screen there. Would you just read that part to us, please? Mr. Polderman?
Yes, these guys are smart enough to pass the bar, but not to become real attorneys. The problem is most people don't fully understand what a receiver is, let alone how to regulate one, combined with the negligence and indifference within the system. And you have the perfect breeding ground for these white collar criminals.
And so, while you were the receiver for Rebel under Judge Dragonchuck's order, were there any other receivers involved?
No,
And so one would be easy to presume that when page 4 refers to the receiver and talks about being a white collar.
I've let him go so far, but he's got to stop leading, he's got to ask questions.
Well, I disagree, Your Honor. This is a bond/sentencing hearing and all the rules are relaxed.
Otherwise, we're never gonna get through this. And you're really addressing a document and using that language to ask a question, so you may proceed.
And so, Mr. Polderman, to your knowledge, were there any other receivers involved in the case?
no,
And so presumably then, would you, in your opinion, did you believe this was about you?
yes,
And do you find that to be harassing, to be called a white collar criminal?
yes.
Turning now to page 5, which would be the next page. I'm going to point your attention to this paragraph that I've made a note, a blue line next to. Can you just read that one, please?
My wife and I have been absolutely terrorized over this the past 3 years by a group of white collar criminals so embedded in the system that it was difficult to tell who was what at times.
And again, any feeling on whether or not you felt harassed by being called a white collar criminal?
Yes, it is harassing.
Turning everyone's attention to page 10. You just read that page for us, please.
Receiver scandal, a story of white collar crime and the negligence and corruption within the system that makes it possible, involving a predatory lender hiring a kill team who specialize in illegally injecting their receiver, using their quote licenses to bypass victims' rights, steal everything they own, and then leave them for dead.
And so, again, harassing to you, being called a white collar or someone involved in white collar crime,
Yes,
and anything reference hiring a kill team.
that's harassing. I find it to be.
Next page just continues. I don't know if there's anything specific to you on that. Page 29, just read the top of that for us, please.
Floyd Gates, John Ruther, John Polderman, 3 individuals who had no business being connected, illegally conspiring together to take over Doherty's company through fraud and racketeering.
And at the top, what's it say?
The kill team.
And are you, and there's a picture, is there not?
There is.
And are you pictured in the document?
It's kind of blurry, and I see
Would it
an
help to
A,
look?
B, and I see a C circled, so I'm certainly not A or B, and I do recognize those to be Floyd Gates and John Ruther. So I guess you can kind of make out C, yeah, that does look like the coat that I own. So yeah, I do believe I'm in that picture. I can see it a little better on the screen there. Yeah, that's me.
Was it harassing to have this filed in a public federal filing accusing you of illegally conspiring together to take over Doherty's company through fraud and racketeering?
Yes,
And to have your picture filed as well?
yes.
This is on page 40. Just read the top one of the 2 lines.
Motive, colon, in-law, this is why one committed the crime, the inducement, reason, or willful desire and purpose behind the commission of an offense. Understand why these guys are fighting with everything they've got yet. That's up to 25 years in prison just on one charge. Floyd Gates, John Ruther, and John Polder will most likely be going to prison for the rest of their lives. They're crafty, but they can't beat the federal government once it awakens.
So once again, when he references you by name here and says that you're going to be going to prison, is that harassing to you?
Yes.
Page 55, you just start reading from the top, please.
Objection, Your Honor. At this point in time, I see Randy has maybe 100 pages there, and I believe this is completely cumulative. We've established the point that the lawsuit was filed. Later, we'll know that he was on a psychotic break when he did it, but more to the point, Mr. Polderman has made it quite clear that reading these things about himself, he felt harassed. He's going to feel the same way when you get to number 75, 76, 88, 90.
Well, but it's his record to make. Right now, I just have a pleading that asserts that. He's attached to like 162 pages, and so I'm going to allow the testimony and you to cross-examine it.
Unless Mr. White wants to stipulate that this is all harassing to the 5 victims. Otherwise, yes, we're going to be here for quite a while going through all these pages.
Let me confer for a minute, Your Honor, if I may.
You may.
So if I may, Your Honor, we will admit the exhibit. We will admit that the nature of them is harassing. But the qualification is we're gonna get into this, this was done by a person who was on a psychotic break.
As long as we're agreeing, then I'm gonna ask Mr. Polderman to stand down. I'm gonna call the other victims to come in and finish watching the proceeding. Because it's gonna be the same type of things, eventually going into the defendant blaming them or blaming some of them for the death of his children. And so with that, I will bring them back in the courtroom and we can proceed. That will expedite things a great deal.
I would like a brief cross.
Okay, get a brief cross and then we'll bring in the other people.
Thank you.
Well, if we're gonna go into crossing, I'm gonna continue with the rest of the testimony.
All right.
Either we're stipulating to it or we're not. If we're stipulating when there's no cross.
That's simply not true. I can stipulate to an exhibit. I can stipulate to the fact that that exhibit has language in it that is harassing. That doesn't mean I don't get to cross-examine it.
Well, you're gonna cross-examine them when I'm done with the rest.
Excuse me, I'm talking to the judge.
Just a minute, if you're stipulating, he's making a record of the harassment, you're stipulating to it, what's there to cross on?
Well, pure and simple. Look, just go. We'll order out dinner. Let him go.
Let's continue now with page 55, Mr. Polderman. Start reading from the top, please.
Meanwhile, Polderman still pays himself thousands of dollars a month after sinking the company. Doherty filed official objections to these fees many times based on fraud and negligence, of which Joyce Dragonshot silenced and suppressed without a hearing.
And when it refers to, meanwhile, Polderman still pays himself thousands of dollars a month after sinking the company, is that harassing to you?
It is.
Turn your attention now to page 59. If you could start reading from the top here, please.
Corrupt receiver, AKA their Trojan horse, John Polderman, P65720, master manipulator behind the scenes, specializing in fraud, illegally siphoning the powers of the courts to suppress their victims while they steal everything they own. He's been sniveling and conniving since grade school, fellow classmate of John Polderman's.
Safe to say that that is harassing to you?
Yes.
And can you tell us what the significance is of P65720?
That's my bar number.
And is, just for the record, is there a picture on this page?
There is.
And what is that a picture of? Is that harassing to you?
Yeah, it really takes another step, obviously referencing people that I've gone to high school with, personal photos.
Turn your attention now to page 60. Titled Doherty's Wife. Is your name on this page?
It is.
And it's in reference to what?
It says Polderman trying to contact Mr. Doherty's wife with no legitimate reason for doing so. Doherty has to send a message saying, John, you are not to contact my wife again in any way. John, you are not to contact my wife again in any way. An example of how outrageous this man is.
Would you have had occasion to contact Mr. Doherty's wife?
I did, because she was in charge of some of the operational sides of the business that I was administering, so I did contact her on occasion.
And so at the bottom where it says an example of how outrageous this man is that harassing to you?
Yes.
The next page is page 61. What's the top of that title?
Show cause, which dragged, silenced, and suppressed.
And then it says motion title. Can you read the rest of that?
Show cause for Mr. John Polderman of Simon PLC as to why he should not be held in criminal contempt for illegally trying to contact defendant's wife multiple times in attempts to harass, manipulate, intimidate when he knew she was represented by counsel.
And then it says see attached, and then I'm not going to ask you to read the rest of it, but it appears, if I'm not incorrect, to be a bunch of cites to various laws.
Correct.
And then it's signed purportedly, we would assume, by Mr. Doherty.
Right.
And is that harassing to you?
Yes, because it says I'm conducting and doing things that are illegal.
Page 62. Starting at the top, please, can you read?
Intimidation, Holderman abusing the law once again and trying to intimidate Doherty into giving up his new home address. Previous email specified home address.
And then there's a screenshot and some writing, but if we could just, for speed purposes, just go down to where the typing picks back up under the screenshot.
This is after Holderman unlawfully kicked Doherty out of his previous home, CMCL 600.2927, sub 3, shown later, which clearly states no receiver shall be appointed over a person's home address, and yet they did. Anything went in Joyce Dragon Chuck's courtroom. Holderman admitted that out of 500 cases he's been involved with, this is the first time he'd ever been appointed over a person's home dwelling, probably because it's illegal.
Is that harassing to you?
Yes, because it's simply not true.
Was the home in question here in Mr. Doherty's name or his business's name?
His business's name.
The next page is page 64 of Exhibit 5. You can start reading from the top. Oops.
Request for immediate removal, motion title, request for immediate removal of the highly corrupted and biased receiver John Holderman of Simon PLC for cause, including an enormous amount of intentional fraud, gross negligence in waste, sadistic behavior, perjury, theft, conspiring to bypass due process and conflicts of interest. After the appointment was sought wrongfully and in bad faith, the receiver continued with the following: repeated criminal violations under Lara, repeated violation of code of ethics, repeated misconduct according to attorney and judicial codes of conduct, all of which have been reported, repeated violation of criminal behavior according to Michigan law and statutes. The motion submitted, including hundreds of pages of detailed exhibits of evidence, and more follows.
I think we're good there. Is that harassing to you?
Yes.
Next page is page 65. Start reading from the top, please.
Disqualification notices sent to all 8 Simon PLC locations. Accountability for criminals. Doherty was falsely arrested a week after these arrived by an elaborate scheme concocted once again by the master manipulator John Holderman.
Let's just turn to the paragraph number 2.
Official notice of PPO petition filed against John Holderman of Simon PLC recently with the court as well for continual acts of harassment and aggravated stalking.
Is that harassing to you?
Yes, because it's not true.
Was there an attempt to get a PPO against you?
That is true. So there was a PPO that Mr. Doherty, several PPOs that he tried filing against me that were all denied.
Next one, start reading from the top again, please.
Simon PLC terminates Holderman after receiving notices.
And then
Holderman finds a new company to abuse his victims through.
And I think you've testified that your current employer is different than Simon PLC.
That is correct.
Were you terminated by Simon PLC?
I was not.
And so is this harassing to you?
It is.
Again, just maybe just shorten this up a bit. Would you agree with me that page 68 is information reference to PPO, and in fact, there's a screenshot of it?
Yes.
Is there anywhere that you recall seeing on here, or take your time and read it, that says that it was a PPO that was applied for but was not granted?
It does not say that.
And so is that harassing to you, that it gives the appearance that he was successful, he being Mr. Doherty, in getting a PPO against you?
That is harassing.
Next document is called Motion to Judge Cole. Could you start reading? Reference what's under that title?
Motion to Judge Cole regarding second PPO Doherty files against Holderman with Ingham County.
And again, is there anything in this that you recall referencing that there was a PPO that was applied for but was not granted?
No, it gives the impression that it actually was granted, and I believe it was in association with this. And Mr. Doherty showed up to my office in a disguise black hat, sunglasses, and asked staff to summon me to come out.
And just so the record's clear, that would have been before March of 2025.
That is true.
And would that have been before August of 2024?
Yes.
Okay, thank you. Next page is page 72, weaponizing the color of law. Do you see your name on that page?
I do.
Do you read starting where you see your name?
John Polderman of Simon PLC using color of law to intimidate a witness, continuing to victimize one of his many victims and deprive them of basic civil rights that all United States citizens are guaranteed. Polderman sending law enforcement to the address he illegally obtained based on more intentional fraud.
Is that harassing to you?
Yes.
And then the next page, that was page 72, so it continues on page 73 with second visit.
So showing up twice in one day, intimidating Doherty and his family a great deal, who also received a call from the Ingham County Sheriff's Department as well. The Attorney General then sent their own officers to Doherty's home days later for a third visit. Based on the same pattern of fraud from one man, John Polderman, of whom Dragonshut continued to enable.
Is that harassing to you?
Yes.
Page 75, titled Retaliation. John Polderman retaliates. Start reading from there, please.
John Polderman retaliates against Doherty for trying to expose him by orchestrating the filing of false police reports by his core group of accomplices involving 3 ex-employees Doherty had to fire for drug dealing, drug using, and grand theft on the premise, along with the tabloid journalists who have been illegally conspiring with Polderman to write smear campaign articles against Doherty for the last year, none of whom should have been taken serious as credible witnesses.
That's enough. Was that harassing to you?
Yes.
Page 77 is titled Emergency Motion Title. This is an emergency and I need help now. Appears to be addressed to Judge Morgan Cole. I'm just going to ask you to read the large font bold at the bottom.
John Polderman of Simon PLC is mentally unstable and currently unraveling as we speak, making all kinds of desperate moves to try and save himself and his career.
And is obviously being accused of being mentally unstable and unraveling, harassing to you.
Yes.
Page 78 is continuing with the title of the page being They Think They're Invincible. You just read the quote at the bottom of the page.
These men led and manipulated by John Polderman just illegally used color of law again to violate my basic civil rights.
And is that harassing to you?
Yes.
There's a document on page 85 entitled SOS from Jail. I'm just going to ask you to read the quote at the bottom.
This is a legitimate SOS of the highest emergency involving a highly sophisticated group of white-collar criminals.
Being called a white-collar criminal, is that harassing to you?
Yes.
Next page is page 102. I have collected an enormous amount of both judicial and attorney misconduct. Looking towards, then there's a screenshot of some kind of writing. You just start reading under that with the quote beginning with my main investor.
And my main investor then hired a team of con artists to come in and act as a turnaround team to help fine tune some things, but were really a highly sophisticated takeout team. There to destroy and take over illegally involving a highly corrupt receiver. Thank you for your time and consideration.
Being called a highly corrupt receiver, is that harassing to you?
Yes.
And being related to a highly sophisticated takeout team, is that harassing to you?
Yes.
Try to speed this up a bit. Starting at page 116. I know you're not necessarily referenced here, but did you see this as part of the lawsuit? Were you familiar with pages like this?
I did read and review the entire lawsuit shortly after it was filed.
And then on page 117, at the top, in all bold between the lines, would you just read that part?
The kill team that predatory lender Boris hired consisted of Floyd Gates, CPA John Ruther, and John Polder of Simon PLC, none of whom were supposed to be connected behind the scenes.
And was that harassing to you?
Yes. So the record's clear, it's harassing.
Your Honor,
because-
there's no question before the witness.
Do you have something else you wish to add to that?
I was gonna say it's harassing because prior to this case, I've actually never worked with Mr. Gates or Mr. Ruther.
Page 118. Just at the bottom, you see your name there, you read that paragraph starting with nothing.
Nothing was ever done by any of the parties. Instead, John Polderman of Simon PLC doubled down on orchestrating an elaborate retaliatory scheme to have Doherty unlawfully arrested on 10/20/23 based on more intentional fraud.
Is that harassing to you?
Yes.
Then on page 119, you see your name at the bottom of the page?
They do.
And what does it say underneath your name?
Criminal mastermind.
And then that's page 119, so then beginning at the top of 120. Is that your business address at the top?
It is.
And then it purports, would you agree with me, to some form of allegations for the lawsuit under that? Under your phone number?
There are securities fraud, racketeering, torture, white collar crime, it goes on.
Would those things all be harassing to you?
Yes, and in fact, because of this lawsuit, our firm had to make a decision to install extra security.
Turn to page 158. In the middle, starting with Doherty's ex-employees, will you read that part?
Doherty's ex-employees aiding and abetting John Polderman of Simon PLC in multiple acts of harassment, intentional fraud, conspiracy to commit harm, and filing of a false police report. 3 of these ex-employees Doherty had fired for drug dealing, drug use, and grand larceny. Polderman then hired them back and illegally conspired with them to have Doherty falsely arrested on 10/20/23.
And then the next one.
Officially reported to Ingham County and Lansing Police Department multiple times, of whom chose to silence and suppress the information to further protect their own.
And so, and we'll hear from the ex-employees as to whether or not they had stolen from the business. But did you eventually hire some of the ex-employees back while you were the receiver of Rebel?
I did.
And would you have done so had they stolen from Rebel?
No.
Page 168. See your name there in the middle of the page?
I do.
You start reading where it has your name.
John Polderman of Simon PLC convinced Andy Crawford, Transnation Title Agency, to fraudulently transfer Doherty's property at 5 Locust Lane, Lansing, Michigan, 48933, completely bypassing marital property rights or all of the intentional fraud that Doherty had informed her of on 2/17/23, along with disregarding the receivership statute 600.2927 sub 3 that clearly states no receiver shall be appointed over a person's home dwelling.
And was that harassing for you?
Yes.
Page 169. Again, in the middle of the page has your name, John Polderman of Simon PLC. We start reading from there.
John Polderman of Simon PLC was furious when he found out Doherty had communicated with Crawford and informed her of his fraudulent behavior and proceeded to completely fabricate a version of Doherty's meeting with Crawford that never actually took place. Even Ann Kraut confirmed twice in writing that John Polderman's version of what happened on 2/17/23 was completely false, but Joyce Dragonchuck and her law clerk, Michael Lewicki, refused to listen once again. Instead, they used John Polderman's false narrative.
Is that harassing to you?
Yes.
Page 170, towards the top, under the line, John Polderman. We start reading from there for us, please.
John Polderman of Simon PLC convinced Maynard Custodian to violate a court order and intentionally obstruct Doherty's ability to provide tax information to the IRS. Instead of listening to Doherty as he informed them multiple times of the intentional fraud, John Polderman was committing Maynard, blocked Mr. Doherty, and cut off all communication with him, intentionally obstructing his ability to provide essential info to the IRS after collecting $150,000 in fees from him.
Is that harassing for you?
Yes.
Summary of allegations, which I would, in my opinion, is not much of a summary since it goes on for many pages. And I'll try to get through it quickly, but I'm going to turn your attention to paragraph 5. Would you read that for us, please? This is on page 190. It might also be on the screen in front of you.
Floyd Gates, John Ruther, and John Polderman had entered Doherty's business on 3/23/22 illegally based on false pretenses.
Is that allegation true?
No, we entered the business on that day, but it was not based on false pretenses.
So is that harassing to you?
Yes.
Paragraph 11.
The problem was every time he went further, these people would contact the very professionals he was trying to report, John Polderman, Joyce Dragonchuck, etc. And we convinced to stand down instead of initiating a proper investigation.
Is that harassing to you?
I mean, that one probably not. I'm kind of confused as to exactly what's being said, but.
Well, maybe the next page, paragraph 23.
Barry unlawfully arrested Mr. Doherty based on more false pretenses presented by the corrupt receiver, John Polderman, the very person Doherty had been trying to warn him about.
Is that harassing?
Yes.
I'm going to skip the bulk of the summary part for purposes of the time of day. So that takes us past page 220. Page 251. Top of it states 3/8/23 hearing with Dragonchuck and Polderman.
Right. Says who James Noyce and Mark Andrick are here in the audience who would later conspire against Doherty with Polderman to have him unlawfully arrested again.
And so the prospect that you conspired with others to have Doherty unlawfully arrested, is that true?
It is not.
And is that harassing to you?
It is.
Page 252, which is the next page, the top starts with Doherty : what's it say after that?
Mr. Polderman is perverting the truth once again.
And then
And it says he's a pathological liar and a master manipulator, and I need that on the record whether you see it or not.
was that directed to you? If you can recall, it sounds like it's referencing a hearing.
Correct.
Is that harassing to you?
Yes, I see a transcript of the hearing above there, yes.
Page 255, top, which reads details of which Polderman intentionally perverted. Without going into great detail here, at the bottom of the page, you see where it says corrupt receiver John Polderman?
I do.
Is that harassing to you?
Yes.
Page 257. This is VS or verse Polderman's ridiculous version.
Right.
Can you tell us, it looks like there's a screenshot. Is that an email?
It is,
And is that from you?
it is,
And then to the side, it's handwritten there. It says 5 false statements in 2 sentences.
right, not an easy thing to do.
And then it says not an easy thing to do. Is the fact that there's 5 false statements in 2 sentences, is that true?
That is not,
And so is that harassing to you?
yes.
Turning to page 260, the top of which indicates perverting justice. What's it say in the parentheses?
Polderman's specialty.
And then at the bottom, it refers to a very serious crime.
Right, considered a very serious crime with a maximum sentence of life imprisonment.
And is that harassing to you?
Yes,
Page 261 in bold, near the middle page says John Polderman is a very sick man. Is that harassing to you?
it is.
At the bottom, it says he's the very definition of a white collar criminal. Is that harassing to you?
Yes.
I skipped some, so I'm just gonna go to 273. At the top, can you just tell us what it says?
It says the neutral receiver.
And when it says neutral, is there anything indicated with the word neutral?
Quotes suggesting that it's well, I'm not sure what it's suggesting, but it's in quotes.
That's speculation. We don't know why put the quotes in.
All right, sustained, move on.
At the bottom of the page, it reads after Doherty is taken away. Will you finish reading that part, please?
John Polderman, Mark Andrew, and James Noyes are seen shaking hands and celebrating in the back.
And then in bold, it says what?
Of whom would conspire together again 6 months later to have Doherty unlawfully arrested on 10/20/23.
Did you conspire with anyone to have Doherty arrested?
I did not.
Page 275 says without ethics. What's in the parentheses under that, please?
More of John Polderman's gang who shared similar character.
And then what is under that?
Without integrity, ethics, or pride, the true story of how Beryl Schwartz and his Lansing City Pulse publication undermined an entire city for greed, profit, and revenge. Soft cover.
And then, so at the top where it references more of John Polderman's gang who shared similar character, in reference to the rest of this, is that harassing to you?
Yes.
Top of page 307 indicates, just read the top part, please.
Ex-employee James Noyes, who Doherty had to fire for drug dealing. AKA the same individual who became Polderman's lead witness against Doherty through the filing of false police reports on 10/14/23.
Was James Noyes an employee of Rebel while you were the receiver?
He was,
And did he deal any drugs?
not to my knowledge.
Is this document, page 307, harassing to you? pretty much under.
Yeah, I mean, it references that I filed false police reports, which is not true, and that he learned how to abuse the system from Holderman.
Skipping ahead again, purposes of time, I'm gonna show you page 311 now. Exculpatory evidence is the title of this document. It just indicates that people were showing up with you to court hearings at the bottom. And while that's not, I'm guessing, harassing to you, do you have any idea what that reference is?
I don't, the only thing I can think of is that they were present at a show cause hearing.
Speculation.
Oh,
First thing you said was, I don't know.
All right,
okay, we'll skip it. That's
yeah.
fine. Withdraw it.
same,
Then let's go to page 312.
Says criminal investigation and accessory charges sought for the following individuals as well. Mrs. Joyce Dragonshock and Michael Lewicki of Ingham County, John Pilgrim of Simon PLC, and then it lists others.
Is that harassing to you?
Yes, because it suggests them being investigated and criminally charged.
Speed things up here, page 315. What's the giant bold at the top say?
By the corrupt receiver.
Being referenced as a corrupt receiver, harassing to you?
Yes.
Starting with this page here on page 319 entitled Ingham County's Witnesses, 3 ex-employees Doherty had fired. A tabloid journalist with AIDS and an abuser Doherty had filed 2 PPOs against with Ingham County. Do you see your name at the bottom of the page there as well?
I do. So John Pilgrim, the guy Doherty filed 2 PPOs against, is in fear for his life.
The fact that he references filing PPOs against you, is that harassing?
Yes,
Technically true, he did file 2 PPOs against you, correct?
he did.
But they were not granted?
They were not.
Skipping to page 321. You know where it says illegally conspiring together once again,
Right.
and it has whose names there? Underlined?
John Pilgrim from Simon PLC, he was serving for the plaintiff.
And I'm looking right here.
Todd Haywood and John Pilgrim, with the arrows pointing to illegally conspiring together once again.
Is that harassing to you?
Yes.
There come a point in time where you were involved as the receiver that you were aware that Mr. Doherty had blamed you for the death of his sons, or the situation with regard to Rebel with the death of his sons?
Yes.
You recall how that came about?
It was one of our first meetings. He mentioned that he had lost, or his wife had lost 2 children, and it was due to the stress of the loan relationship with the lender.
And in this filing, was there a reference to the death of his children?
There was.
Page 368.
Yes.
And then on page 369, twin boys, and has a picture. I think further into the document, it'll explain that Mr. Doherty was holding his children.
Right.
And then the page 370 is titled manslaughter.
Right.
Your name isn't on that document?
It is not.
And then page 371, he filed death certificates, but it's certificates of cremation for the two children.
Correct.
And then in page 372, the next page, he shows a Michigan compiled law for manslaughter.
Correct.
And then on page 373, bad faith, you just start reading that.
Bad faith after their first meeting, 2/23/2022 or 22. Floyd Gates tried to relate with Mr. Doherty 3 different times on his dead children within a 2-hour time period to the point of being extremely awkward. Doherty assumed he was just socially off.
And then does your name appear on that document towards the bottom with the paragraph that starts with he did, if he didn't?
If he didn't, they had a plan B lined up to wrongfully appoint their connected receiver, John Polderman, as well.
So while not directly blamed for the death of his children, I suppose in those documents, is that still harassing and troubling to you?
It is.
And is that troubling and harassing the totality of everything we've just gone through with the fact that you're an attorney and work with people who have access to Pacer?
It is.
Have you ever just Googled your name to see if any of this comes up?
I have.
And what happens when you do that?
Some of it does. Title of the lawsuit does.
I have no further questions, Your Honor. Thank you.
Off the record for a few moments. Thoughts? Back on the record.
Your Honor, at this point in time, I've invited the other witnesses and victims into the courtroom. I had sequestered them. It's almost 5 o'clock. It's gonna be much of the same of what we just saw, so I'm gonna, from my belief, I've established harassment at this point, so I'm just gonna move on to the next topic after the cross. I don't think it's needed at this point in the day to belabor that point. So we're gonna just leave it at that, and then I'm allowing them back into the courtroom.
Counsel?
Understood.
All right, we may proceed.
Pat? Name's Toby White, Mr. Pulp. I have a few questions for you. An easy one is, you don't have to be a lawyer, but you do have to pay to get on PACER.
The firm must pay for it, but that could be.
Okay. And tell me again, that how did you become aware of the lawsuit?
Several people notified me that there was a filing of the lawsuit.
Those people would be?
Mr. Gates notified me, and I'm trying to think of who else did. I'm not sure the second person, but I know Mr. Gates did.
Okay. All right. And you've been through these countless witnesses, then, I'm sorry, exhibits, statements that were made and attributable to Michael Doherty. And you may have said they're harassing. Is that true?
It is.
Okay. Let me ask you this. In working with all of this, did you ever discuss any of the allegations that Mr. Doherty was making with anybody else?
I did.
And during those discussions, I'm sure that you or others said, this is crazy.
I'm sure that word was used over the course of time. We've been at this now for 4 years, so.
All right. And there was some commentary about fees. You did get paid for the work you did.
Mostly, I'm still owed some money, but I did mostly get paid. That was true.
Okay. And then some of this that has been shown here to the judge clearly falls in the range of harassment. I get that. That would be the case, except for one thing. We're lawyers. People call us names all the time. So why is this particularly harassment and not just annoying?
Well, that's a fair statement. I mean, I've been at this for 22 years, and receivers can often be the lightning rod for controversy because people don't like their stuff being taken from them and sold or liquidated. So part of that certainly comes with the territory, but in this case, it got progressively worse, right? There was actually the relationship started off civil of Mr. Doherty and I, and somewhat cooperative, and then it degenerated. And then there was text messages that were harassing.
Okay.
Then it developed into, I think the first blow up was really with the sale of his home. He was angry about that. So he showed up in person to the title company, which was unusual, and tried to, I mean, I won't reiterate everything that's been filed with the court, but things then really took a downward spiral when he started emailing me probably almost daily. Then he would copy my staff, then he would copy the owner of the firm, then he started copying, it had to be over 100 people. I mean, he would continually accuse me of being a pervert. He attached photos of my uncle that had passed away, commenting on his appearance, got into my personal Facebook page. It goes on.
All right, so that goes on and on.
So then, and
And so you,
leading up to this lawsuit, which is kind of the crowning piece of that, after a number of years, it's reiterating many of the same things he said. So any one of those pages in isolation, I would agree with you, right? Okay, somebody says you did something right, it's not that big of a deal, but the cumulative effect of that over a number of years
is what brought this to be, okay, to what brought it to your mind to be harassment.
that is correct.
All right, now, interesting, there was some contact with Michael Doherty's wife.
Correct.
Was she represented at that time?
Not to my knowledge. I don't know that anyone
Did
ever
you ask
had an
her?
appearance.
Did you say, are you represented?
Well, when that was sent, it would have been after we had had a continuous time of contact. So typically, as receiver, I'm also an attorney, but I will have to step in and speak to people. So I spoke to Mr. Doherty, and he was represented, and that was fine with his attorney, because we're talking about non-legal things, right? Who's gonna pay the light bills, your insurance lapsed, who's going to be showing at work today. So Mrs. Doherty handled some of those administrative things. I don't believe, well, in fact, I know she wasn't represented by counsel because she wasn't a party to the lawsuit. So she would not have had counsel, never said, hey, you need to talk to my attorney, I'm represented by so-and-so.
All right, and do you know from your personal knowledge if any employees stole from Mr. Doherty's enterprise?
I'm trying to think, I'm not aware of anybody that stole from his enterprise. Well, I take that back. So there were some employees, none of whom are present here today, that I never physically saw them steal anything, but there was assertions and allegations that they had stolen some weed. Because it's a cannabis grow facility, so there was always suspicion that somebody would be putting product in a backpack or their pocket. So I do believe, even though I didn't witness, there was one employee, I don't even remember his name, where a number of people said they thought that person was stealing.
Okay.
And I terminated them.
All right. And who was the person you terminated?
I honestly couldn't tell you the person's name. I do know it was not anybody present in the courtroom today.
Okay. You are aware that Mr. Doherty has been at the forensic center 2 times.
I've been aware that he's at the forensic center, but I don't know how many times.
Okay. And you're also aware that he was there because he was deemed incompetent because of a psychotic break.
I've reviewed the entire federal docket, every pleading that's been filed, and at the Sixth Circuit Court of Appeals. So I've gathered whatever I know is based on those pleadings. So I saw something with the forensic center and he was being sent back and forth. I generally am aware of that.
Okay. So we're clear about this. You were aware that he was going back and forth from the forensic center.
Yes.
And those dates, are you clear on those dates?
I am not.
All right, so those dates could have corresponded with the period of time when he was filing this mega suit with the feds.
My recollection, I
Don't speculate.
Yeah, I don't want to speculate. I do know that when he filed this lawsuit, he would have been out of jail because he attempted to serve it on the prosecutor, which led to him being re-incarcerated.
Okay.
So yeah, when he drafted this, I don't know.
All right.
I don't know.
And you're aware that there was a period of time when he was deemed competent in between the two stays at the forensic center?
I don't know.
Don't know? Okay. Don't want you to guess. Your Honor, may I confer for just a minute?
Me,
One last question. I don't know much about receiverships, but it's my understanding that a receiver is not allowed to take possession of someone's personal home.
So I'll try to be succinct because I could give you a half-hour answer. So there are a number of statutes that govern receivers. One of those is MCL 600.2926, which is a general appointment statute that says a judge has discretion on appointing receivers. There's another statute that references waste that's being committed on a property, and there's a mortgage, somebody holds a mortgage or assignment of rents. So that's another way that a receiver could be appointed over property. There's a mortgage and taxes aren't being paid. That's a separate statute. Then you also have the commercial receivership statute, which is MCL 554.1011, which talks about appointment in the context of a default on a mortgage. And
I don't want to cut you off, but
right.
for his home, Michael Doherty's home, what was the statute and the basis for seizing it?
So his residence was actually not titled in his name personally. It was titled in the name of the company.
Okay.
And part of the authority that allowed me to sell his home, so the receiver order originally did not include his home.
Mm-hmm.
So there was litigation back and forth, and we had a settlement conference, I think just down the hallway, and we all got in a room and said, how can we resolve this? So there was a stipulated order that would allow Mr. Doherty a window of time to try to sell the business because and the real estate because he believed he had a buyer.
Okay.
So there was a stand down provision. And then as part of that, he stipulated, so he agreed to his house being included in the receivership and being sold and administered by the receiver. So it was part of a settlement order that he stipulated and signed off to and hit council president at the time. So I do understand that statute. I believe, without having it in front of me, that it's in the context of default on assignment of leases and rents or waste. But I can assure you that for 22 years, I have sold residences in receivership, mostly in divorce cases, where there's a judgment of divorce, court orders the property to be sold. Usually it's the husband doesn't want to sell it and refuses. The judge appoints a receiver and it's sold. So that goes on all day, every day in courts throughout the state of Michigan. I would also concede, though, that under that statute it references someone's dwelling, but that was not the statute that I was appointed on. I don't even know if it referenced a specific statute, but he also stipulated and agreed to it in exchange for this window of time to try to sell the business and real estate.
sir, we're not talking about just a stipulation and agreement. We're talking about him being part, Mr. Doherty being part of the full negotiation as well. This wasn't done between council and then he signed it. He was part and parcel of this whole package. Is that correct?
He was, I remember we walked into the side room, he was there and his attorneys were there.
Thank you. You may proceed.
Last thing, do you remember the approximate date of that agreement? Month and year, maybe?
Well, when was the house sold? It will probably, I think it was, let's see. So if I was appointed in 2020, I was appointed in 2022. So we would have, in March of 2022, we would have reached that agreement. Maybe I would guess summer of 2022. And there was the default. I put the house up for sale. I want to say we sold it in February or March of 2023. So that would have been when he went to Ms. Krupp's office. So I'm a little hazy on my dates, but I know it was, I know we had to have the house winterized and it was cold. And we had it higher and then sold it.
All right. That's all I have.
Redirect.
Thank you. Mr. Polderman, you were asked questions about being an attorney and having to, I suppose that opened you up to some form of harassment. Remember that question?
I do.
Was the fact that we went over was filed in a federal lawsuit also harassing in and of itself?
Yes.
No further questions. Thank you.
Will this witness step down?
Yes, Your Honor.
Thank you. You may proceed.
As I stated, I'm not going to call the other people.
All right.
I will call Miranda Gale from probation, Your Honor.
Thank you. Raise your right hand. Do you swear or affirm the testimony you're about to provide be the truth, whole truth, nothing but the truth, under penalty of perjury? Thank you. You may have a seat. When you are comfortable, feel free to adjust the microphone. Please state, spell your name for the record.
Miranda Gale, Mirandagale.
Ms. Gale, were you employed?
Ingham County Probation.
And were you asked to supervise Michael Doherty during a bond delay of sentence?
That is correct.
And ultimately, was that delay of sentence supervision transferred to a different county?
Yes, it was Charlotte.
Thank you. Was there a point in time in April of 2025 that you learned that Mr. Doherty was in your office?
Yes.
Do you recall the specific date?
4/1/2025, I believe.
Were you aware of why he was in your office?
I believe I received a phone call from my supervisor as I was not in office that day. And she had informed me that he had sent or brought a subpoena to the Ingham County Probation Office.
And do you know what what case that subpoena was in reference to?
It would be in the RICO case that he filed, the federal case.
The federal case, not the case that you're here on today?
Correct.
Thank you. I'm going to show you what's contained in my motion as exhibit number 2. And it's it's a court document. It's got the judge's signature on it. So I'm just I'll just do it from here. It's going to show you recognize what this is.
Yes.
And at the bottom here, you sent this up to Judge Aquilina, did you not?
Yes, I did.
And at the bottom, it appears as though Judge Aquilina signed that.
That is correct.
And she made some notes on it directing you to do some things.
That is correct.
And I hope it's showing up okay, yeah. Starting here, what did the judge write?
Cats can complete medical evaluation, and if not an option, we'll send to forensics.
And then what's next here?
If PSIR can't be completed in, I'm sorry, I don't know that word, please prepare verbal.
I think it says it can't be completed in writing. Please prepare verbal and come
to
court at sentencing.
That is correct.
So after you received this from Judge Aquilina, did you attempt to interview Mr. Doherty?
I did.
And what was the purpose of that? Was that for completing the PSIR?
It was, and to get a release of information signed.
In reference to the PSIR, did he cooperate with you?
No, he did not.
In reference to signing the release of information, did he cooperate with you?
No, he did not.
Would you explain to the judge a little bit about what happened when you went to go visit with him?
Yes, I went in 4/11/2025 and to the Ingham County Jail. And I asked him to sign the release of information, and complete the PSIR. And he told me that he was not signing anything or answering any questions until I answered his questions.
And what did you do at that point?
I told him that I wasn't playing a game with him and that this was something court ordered and that I wasn't gonna answer his questions for a signature or for answers to his questions.
What happened next?
He continued to decline and refuse to sign and answer questions.
How did the meeting or interview end?
It ended when he was visibly getting upset and the deputies kind of came over and I just said, all right, well, we'll have someone else come talk to you or you'll have to talk about it in court.
In your opinion or towards you, did you feel that you were being harassed and intimidated in any way?
I don't believe I was being harassed, but he was trying to intimidate me with probably his size and just the ability to want to get those answers. That's how I felt at the time, yes.
At some point in March or April of 2025, did you become aware that Mr. Doherty had switched doctors?
Yes,
And I don't mean counselors for therapy, I mean doctors that would be prescribing medication.
that is correct. I believe his agent from Charlevoix informed me that he had just found out that he received, or he was put on no medication or new medication, and he had to receive a new doctor, which is a family doctor.
Did you do anything after you received that information to try to confirm that back up in Charlevoix with the doctor?
I did. I sent a special because they had no power at the time, so the phones were out. It was like in the middle of like an ice storm up in Charlevoix. So I sent a special so that the agent in Charlevoix could try and like reach out to the doctor and talk to the doctor. From what I understand, they were closed also from the storm, I believe. And at some point I did receive a phone call back from them and they informed me that there was no release on file and that they could not talk to me.
When you say you received a call back from them, who is that?
The doctor's office, but for the doctor, he reported.
And to your knowledge, was there an order of the court that Mr. Doherty was to continue with his counseling, correct?
Yes,
Continue taking his medication, correct?
correct,
And sign all necessary releases so that you could confirm that those things were being done.
yes,
And so what you're saying is when you called this purported new doctor, they wouldn't give you any information because there was no authorization or release of information on file.
yes, that is correct.
And it brought to your attention then that Mr. Doherty was told by this doctor, supposedly he could quit taking his medication.
That is what Mr. Doherty informs us. I can't confirm it with the doctor because I didn't have the release.
I have no further questions, Your Honor.
Ross?
Good afternoon.
Good afternoon.
That exchange you had with Mr. Doherty that you just described, that was in April of what year?
2025.
Okay. And you were aware that he had psychological problems.
Yes,
And so from your own knowledge, do you know if he missed any counseling?
I'm sorry,
Counseling?
no, he did not miss counseling that I was never informed of.
Okay. And the same would be true in terms of he went to a doctor in Charlevoix.
Yes, I believe it was never reported he wasn't going to a doctor. I just believe we weren't aware there was a change in a doctor or which doctor it was.
Where did he change doctors from? He went right to Charlevoix.
I am unaware.
So I don't know why you're using the word change. I mean, he went to Charlevoix and he signed up with a doctor, right? He didn't leave one from Lansing.
I wasn't supervising at the time, so I would not know.
Okay. Fair enough. And then Mr. Doherty did reference that he was working with the doctor to reduce the chemicals, to reduce the pills that he was taking.
I was informed of that by the other agent, yes.
All right, okay. So when you come right down to it, you cannot tell the judge here that he switched doctors without permission. And you can't tell him that he wasn't taking his medication as prescribed or not prescribed by the doctor he was seeing in Charlevoix, right?
He would be required to inform us of any doctors he is seeing, and my only concern would be the Charlevoix doctor did not know that that doctor even existed. So then that's why there was no release and no updates while he was on probation from that doctor.
When did you ask him to sign an ROI?
He was asked at his initial orientation, so he would have done it in Charlevoix when he met his agent.
Okay. You have that document?
This time.
So you don't, again, you don't know from your own personal knowledge if he signed that for probation or not?
I believe that in the file in our system, there was a release of information signed by Mr. Doherty for Amanda Fettig, which I believe is his counselor.
Correct.
There is no doctor listed on the same ROI.
All right. Confer for Senate, Your Honor.
You may.
And you are aware that Mr. Doherty was experiencing a second psychotic break in that period of time, April of 2025?
I can, based off of his actions, I had concerns that there was something going on, yes.
So you won't dispute that?
No.
Okay. I think that's all I have, Your Honor.
Thank you. Redirect.
Thank you, Your Honor. Ms. Gale, I'm going to show you what's marked as my exhibit number 1 to my motion, which is a document signed by Judge Aquilina. What's the date here at the bottom?
August 19th, 2024.
And if we look here, does it not say you continue counseling therapy, follow all recommended or all recommendations? I leave that to the court to decipher the writing, but it does next say, sign all releases so we can verify doing what needs to be done. Does it not say that there?
It does say that.
And again, in April of 25, when you called this new doctor or the original doctor that he found up north, there was no release sign, correct?
That is correct.
And so logically, correct me if I'm wrong, if he started with the doctor and was on his meds, that point in time, he didn't sign a release of information, correct? Because there's none there.
Correct.
And so if the doctor told him he could then wean himself off his medication and at some point he became incompetent, that's irrelevant because when he first started with the doctor, he presumably was on his meds because that doctor,
No, that's an argument.
according only to Doherty, told him he could wean himself off, correct?
Correct.
And you've never been able to verify that with the doctor.
I have not been able to verify that.
Thank you. No further questions.
Did you have follow-up briefly?
Just a brief follow-up. For Mr. Doherty. And the ROI. The ROI is something that you or someone else, another agent, gives to him. Correct?
In the beginning, yes. If he was to get new doctors or something, he would have to have it signed and tell us and inform us he had a new doctor, and then we would have to fill out a new one.
Okay. And still, as we sit here today, I hate to beat this dead horse, but as we sit here today, you don't know that the doctor in Charlevoix wasn't his first medical doctor.
I don't.
Okay. And I have one more. Give me 1 second. And the squabble over the ROI that happened at the Hingham County Jail,
Yes,
that happened in this period of March 28th through April 3rd or 4th of 2025.
It would have been, when I went to the jail on April 11th,
Okay.
2025.
Very good. And at that point in time, you know that he had been recommitted and that he was having a psychotic break.
Yes,
Thank you, Your Honor.
Ma'am, so I wrote on this order that the people referenced, continue counseling / therapy, follow all recommendations by shorthand was Rex, I read it all day long. And sign all releases so we can verify doing what you need to be doing. That was signed August 19th, 2024, and ordered by this court. Let's suppose for a moment, by April 11th, 2025, he's having a breakdown. Do you know how many releases he signed between now, or between the signing of my order on August 19th, 2024 and April 11th, 2025?
the only updated or uploaded releases, which is what I would have access to, which is from Charlevoix, is for the counselor, Amanda Bendick. There has been no other release signed and uploaded and given to me for information.
So is it fair to say that you are surprised that there were other doctors because you have no knowledge of that?
That is correct.
And the minute that it's not signed, meaning the release is not signed, that is a technical violation, isn't it?
That is correct, Your Honor.
Well, I would just dispute terming it as a technical violation because that purports to probation and we're not.
I mean, I don't mean in the probation.
Technically
but
would be a
technically,
violation,
yes,
yes.
Thank you. Thank you. You may proceed.
I just have one follow-up question. It's not just the fact that the release wasn't signed, correct? It's also that you didn't even know what doctor to contact until March of 2025.
That is correct.
Thank you. No further questions.
May this witness step down?
Yes.
Thank you. You may step down. Any additional witnesses?
I don't think it's necessary at this point, Your Honor.
Any witnesses?
May I confer for a minute? I know it's
Yes.
after 5. Let me confer for a minute. Your Honor, I have no witnesses.
Thank you. Argument.
Thank you, Your Honor. I'm going to be brief, the best that I can.
Your Honor, 1 minute. We're good.
Thank you. You may proceed, counsel.
Your Honor, it seems to me that the whole point of the questioning from Mr. White is that Mr. Doherty was experiencing a mental episode when that lawsuit was filed. I don't dispute that. But the bond conditions and the orders of this court were set up to prevent that. That was the whole point of all of it. He entered the plea in August of 2024, and we know by March of 2025, he's back at what he was doing prior to the first competency. And so I would purport to the court and submit to the court that the length and sheer volume of that filing in the federal court wasn't done in a day. So there had to be some time prior to the March 2025 that the defendant was off his medication. The problem we have is he violated the conditions of this court because he did not tell probation who his doctor is, nor did he sign the release. We still don't know whether or not that doctor took him off his medication, and perhaps he or she did, but that's the whole point. He didn't tell us, didn't tell probation, didn't do what he was supposed to do. For all we know, he took himself off the medication. For all we know, a doctor told him to do it.
Ron, I'm not allowed to speculate like that.
It's closing,
It's argument, I'll let you have yours, let's get through this, unless you'd like me to call in dinner for everyone. Counsel, you may proceed.
the whole point of this was set up, Your Honor, so that Mr. Doherty could prove to the court, prove to me, because I was the one who entered in the plea agreement, that he could do a year of taking his medication and not acting out in this way. It didn't take but a few months, August to at least March or sometime prior to March 20th, 25. And so that's why we're here. I allege that there were 3 violations. The harassing behavior of a protected party you heard from John Polderman. I'm not going to rehash all that, but to sum it up very briefly, he's an attorney being called a white collar criminal. And that's filed in a federal lawsuit that anyone with PACER has access to. He showed up in court when this court, looking at the court's order, he was not to have contact with Ingham County unless it was from court, for court. Sure, they're going to argue that he was here for court because he was serving subpoenas. He was serving subpoenas to me or someone in my office and to the probation department for his federal lawsuit. You can't skirt the court's orders by filing what I will say it's a frivolous lawsuit. It's been dismissed with prejudice, and create your own court so that you can come to this county. When this court said only come to Ingham County for court or attorney meetings. So he violated, in my opinion, for that. And this court, I didn't put any evidence on because this court's a witness to it because you revoked his bond on April 1st, ahead of my April 2nd emergency hearing to revoke bond because of the federal filing. So we have the harassing of a protected party, we have the being in Ingham County, and third, we have the fact that he didn't comply with this court's order for treatment, counseling, and medication. And anything that said that all these things happen during a mental break, I agree with, but the purpose of this was not to have mental breaks. And it was to let probation know what you're up to and what you're doing. But when you go to a doctor and you don't tell anyone that's your doctor, when you go to a doctor and you don't sign a release so they can follow up and find out what happened, this is where you end up. And so I'm asking the court to enter the 2 felony convictions. I believe the court, no matter what, has set a sentencing, I believe it's June 18, and order the defendant to work with probation to do the PSIR. And further, the last thing I want to order is that, again, he stay at the forensic center and hospitalized by the state to maintain his medication so that he is competent for sentencing so that we can finally put this case to rest.
Counsel?
I think I've been pretty clear, this is a mental case. This is not a criminal case. We're in a criminal court, I get it. But I think the point is that Mr. Doherty had a break. He lost twins, lost his business. You know, it all went south and went way south. And he started looking for answers in the wrong places and the wrong people. We know that from the nature of that enormous federal suit he filed and the papers that he filed with the 30th Circuit Court. However, we're not here to say, oh, look, he had this nearly technical violation and that nearly technical violation. Let's ruin his plea. We worked very hard on that plea. And for him to have a breakdown when, you know, like I said, in opening, it's a reverse. Normally we're standing here, my client's sitting there and he's like, I thought I had it licked. He's saying the same thing, but the difference is his having it licked was he thought working with his doctor, he could stop taking his medication. It didn't work out. I have had numerous conversations with the forensic center. They are firmly in the camp of get him set up with CMH in Charlevoix. His family has gone, found 2 competent psychiatrists, not a family doctor, so that he can be supervised properly. And that supervision could go well beyond any kind of probation that's instituted. What he has is a really, really tough problem. And so I think that we owe it to him to give him a second bite at the apple and to try to move forward And so one day he will legally come down to this court and say, look what I've accomplished. Because of the sentence that you imposed on him and having the additional felonies versus the misdemeanors, you know, we know that it would be much better for him progressing forward to have those misdemeanors and not those felonies. And I would remind the court again that the harassment's there and so far, but nobody was injured. Nobody even got close to being injured, just words and silly pictures and things like that. So I would ask you to leave the misdemeanor in place, schedule a sentence hearing. I will have Lindsay Corso, who's working with him here at sentencing. And we can go from there and put him in the right program. And you've heard me say it before, guardrails. Let's get good guardrails this time. He was put in junk guardrails. And it's a shame, but that's why we're here, because of bad guardrails. We're not here because Doherty thumbs his nose at you or the probation office. Thank you.
Final word.
Yeah, I find it offensive to say that what happened here hasn't hurt anyone. I think the court heard from Mr. Polderman. I think it's very injurious to him. And again, I think much of what was just said is really allocution for sentencing. And I sympathize. I do understand Mr. Doherty has mental health issues, but again, this whole thing was set up for him to succeed and he failed. And I ask the court to enter the 2 felonies and proceed. Thank you.
I've heard the testimony, I've seen the boxes of evidence, and of course, counsel and I have met numerous times on this matter. What I finally agreed to was this delayed sentence, so we could watch him. I finally agreed to allow him to go to Charleroi. I finally agreed to release him on bond and set up these parameters to continue counseling, therapy, follow the recommendations, sign everything, so we can verify he's doing what he needs to do. That was for his protection as well as the protection of the victims, the community, everybody. Long before April 11th, when the breakdown occurred, even if it occurred a month prior, I don't know when it started exactly. Clearly by April 11th, we do have testimony that there was a clear breakdown in mental health. He takes it upon himself to not inform us, as I ordered, of doctors. I don't know, and we can't verify what he did or did not tell the doctor. All I ever want, and I believe I explained this to everybody, probation doesn't ask to violate HIPAA, but wants to know who the doctor is, you're taking your medication, following all your recommendations, all of those things. We couldn't even do the very basics of getting a name of a doctor to even verify he went to a doctor, which clearly violated my orders. Then we get into this harassing behavior that includes, he's not supposed to show up in court. And it's a flimsy excuse to say I had to show up to serve, because he didn't have to show up. That's why we have process servers. Could have entered the court through a process server and filed whatever documents he wanted. It's his right to file if he feels offended by something. Clearly, the federal court agreed there was nothing there, but nonetheless, he didn't just stretch the order, he broke that order. There were options that were viable. He chose not to avail himself of those. He chose himself not to sign the required releases. And then he does not follow up with the proper treatment, counseling, mental health, and there is a decline, which we knew would happen, which is just the sole reason everybody worked together for this agreement. And I agree with the prosecutor to say that Mr. Polderman was not injured is ludicrous. And I know, counsel, if that happened to you, you'd be the first one in here saying, you gotta stop this. We need a gag order. We need this or that because it's ruining my reputation. To call an attorney a white collar criminal, corrupt, to interfere with his Facebook, call him unethical, a criminal, accuse him of manslaughter, all the things that went on are above and beyond just a little lawyer joke. Very serious allegations, every single one of them can ruin an attorney's reputation, and all we have, and you know this, sir, is our good name. And once it is soiled, you can't get it back. And you did everything you could to undermine not just Mr. Folderman, but Judge Dragonchuck. And by the way, she's not my favorite person. But I don't care who it is. The treatment of her, the treatment of counsel, the treatment of so many people speaks volumes. I understand that you lost children, and I have twins. I can't tell you how much I bleed for you, but that was God's hand. For whatever reason, he gave you a gift and then took it back. It had nothing to do with any criminal activity. And for anyone to be accused of such a heinous act is deplorable. And while you may not have been in your right mind when we got these thousands of papers from you, we did everything we could to make sure that you would stay in your right mind, that you would take your medication, that you would see the proper doctors, that if we thought you were falling off the wagon, we could help put you right because we had the information. You had 2 probation agencies, Ingham County and Charlevoix, following you, monitoring you, but you didn't help them help you. I compromised on these bond conditions to no avail. They failed. And I'm sorry about that. I apologize to all of your victims for that. Maybe I should have left you in lockup. Maybe I should have left you at the forensic center. I feel horrible about that. Because maybe if we would have left you there, this plea would stand and you would have the misdemeanors. But sir, you have violated in so many ways before you became mentally ill. But I do find that you ended up being mentally ill because you didn't follow the orders of the court in many, many, many ways. You are in violation of the orders of the court. You are in violation of this agreement, and the 2 felonies will stand. You have broken the agreement. So I need you to work with probation to complete that pre-sentence investigation report. The question is, where do you do that? Are you on your meds now, sir?
I am,
And where are you living?
Charlotte.
And who are you treating with?
Well, as far as, I'm in the forensic center right now, but I want to go back to Charlotte. So you're asking me who?
So do you have a plan with the forensic center in terms of treatment?
Yes, ma'am. We, Lindsay Corso, who I believe is part of this hearing, she has a plan ready to go. They need a few days to put it together. So as long as they get a release date, as soon as they do, we have a psychiatrist lined up and CMH, all that stuff. And Your Honor, I have learned, and I do apologize to this court and everyone involved, that this was not my intention. I had obviously been hurt a little bit, but I look back, I realize the errors, and I do apologize. And I'm looking to just move forward with this whole thing. I did have a psychotic break here. Ms. Gale, I apologize to you. Our interaction wasn't the greatest on 4/11, but I was ultimately scared, locked up again, the last place on earth I wanted to be. And really, truly, to the other victims, I apologize as well. My intention was never to hurt others, only to stop being hurt myself. And I know I didn't go about that the greatest way, but I know that now. And now I'm back on the medications. I've had great counseling. Randy Berman, I apologize to you as well here, because I know him and my attorney, Mr. White, worked really hard on this plea deal with yourself, Your Honor. And so last thing I want to do is let anybody down. And that's why I would really appreciate one final consideration into letting me have one more go at this. You know, the felonies, I'm an architect and a professional at my core, and having those felonies on the record for the rest of my life or however long, it's going to be really detrimental to me, my mental health, all the above. And I would really ask the court to at least just consider giving me one more shot at this original plea.
So I'm not going to do that. And, you know, if you can stay clean for, 5 years, you can certainly have it expunged, but the message has to be sent. You really need to be on the top of your game. If you had cancer, you'd be going to chemo and taking all that medication. You need to stay on your medication. To go to a doctor and convince a doctor that you can do it without medicine, and that doctor doesn't have your full history, and we don't know that doctor, that speaks volumes if you want to take control of this. And sir, you've hurt so many people. I would not be doing my own job if I were to let these misdemeanors stand after all of this. You know, you are the nicest guy when you're on your meds. You make perfect sense. You've apologized. I've seen so many criminals, you know, probably 90% of them do not apologize. I appreciate that you're taking responsibility, but sir, you've got to stay on your meds. So we're gonna watch you and work with you, and I'm not gonna let you out until sentencing when I see a plan, and it can be in Charlevoix, but again, I want the doctors, I want verification. I want a solid plan in place that you agree to follow, and we're going to watch you for the full 5 years. And, you know, if you do well.
They have it ready, Your Honor, just to let you know, they have the plan ready, they just need an outdate as soon as they give.
The outdate would be if everything goes well and everything's in agreement and there's safety plans and all of that, it will be the day of sentencing. But I don't have a crystal ball, so could that change? Yes. I hope it's the day of sentencing, sir. You don't need to, we have other people who need to take up the bed space. I need you on your meds. I need you at the top of your game, and the assurances that you're gonna stay there. I deal in evidence, and the evidence I see here is a problem. So again, sir, I see a lot of mental illness. The problem with you is that we worked so hard to make sure you were going to stay on top of your game, and you sort of blew it all up. And I understand you have a lot going on, but I need some assurances. All your victims need assurances. You actually instilled fear in very strong people. And a reasonable person would feel fearful with what you did while you were not on your meds. So it's important you stay on your meds. We have this period to make sure that you are on your meds. June's right around the corner. We have a sentencing. I need you to work with probation to get a good pre-sentence investigation report, a handle on your plan, your doctors, your meds, all of that. And then am I willing to let you try that plan out? Absolutely. Okay, you deserve to have a life outside of jail, outside of prison, outside of forensic center, if you can abide by the rules. And if you can't, it's a problem. And we'll deal with that then. So what is the sentencing date?
June 18th at 1 o'clock. Currently, I believe the bond status is still revoked. And
Still revoked, or we'll address bond on June 18th, 1 o'clock.
Defendant is to be returned to the.
Return to the forensic center to continue on his meds and to put a plan in place with his doctors there, his Charlevoix doctors and probation there and in Charlevoix. So everybody's on the same page. Sir, this is for you, whether you believe it or not. Things don't happen to you, they happen for you. This hopefully is your last psychotic break. You get a handle on it and your life will soar. You certainly are talented. So let's stay on the meds and show the world your talents, not the demise of you.
If I can say one, the felonies, is there, Mr. Berman, is there any way?
No.
And even no. the other victims here, guys. I honestly, we were good at one point. I heard each of you, and if you don't mind.
I do mind. Here's the thing. I don't play let's make a deal. I already did that and it fell flat. And you are asking victims to feel sorry for you. Feeling sorry for someone is not an element of any crime. It's not part of the negotiation after I've done my orders. And quite honestly, sir, there's laws that the prosecutor can bring, and we can have another hearing if you wish. But with a valid plea and a valid plea agreement, my hands are tied. I have found you in contempt. I have found that you violated it. So we have a valid plea and the felonies will enter. And so let's make a deal is way off the table. It's a game show. Feel free to watch it, but not in this courtroom. Anything else for the record?
No, Your Honor, thank you.
Nothing, thank you.
Thank you. That's all for the record.
Thank you, Your Honor.
Orders to reinstate the two felonies and proceed to sentencing on June 8th.
Take care of yourself, okay?
But that was
Thank you, Your Honor. I appreciate it.
I just, whether the attorney or court is going to